How are you?
Good in yourself.
Toilet is a person.
Morning. No, Mfundo doesn't listen and I was explaining things I'm not asking. Very long. It's all of me. Yeah, so Mfundo doesn't listen. Mfundo teaches. Because, you know, I've got this boy. It is the son. So I'm trying to bring him with us for about something like Parliament denied my entitlements. But I fell in full time. So it doesn't matter that I'm English. So I wanted to follow to then say, okay, because I have my entitlements and I'm struggling with my entitlements, how can you help me with this one? Who doesn't have entitlements? And so far, the only chief flight is sub-A. But sub-A, as long as I'm going to learn, they take it. Hello, sir, how are you? Today.
I think it's next week, 28th, next week. I don't know. Seems like blank. So it's what advisable to maybe expand the level time.
Either left or lost my reading glasses. So I'm like a blind bat.
Oh. Would it be lost? Would it be lost? Would you have lost them?
I think I sent it. You come send me Russian because I have a telephone conductor with us. I called the bank leader gating
you were saying there's only 2 people in the
Good morning, good morning. It's 10 o'clock. Secretariat, can you establish if we have a quorum to begin, please?
Good morning, Chairperson. We have a quorum to proceed. Thank you.
Haven't tasted this one.
Good morning, honorable members. Can I request that the parties just round up their members? We have 5 members present, which means that we can start the meeting. But for any decisions that we need to take, including the adoption of the minutes, we need a quorum of 6. So our quorum is a bit faulty. If we can just take 2 minutes and allow the parties. Thank you, Madam. All your members are here. I'm not sure, maybe the Secretariat can advise us, because the small parties, we've had a resignation in the committee, which was not formally tabled in the committee, but has there been any indication from the parties in terms of what is happening there?
Chairperson, we did have a resignation, Ms. Wilskut. The only thing we got is that she said she's resigning. Nothing formal as yet. I have checked with Mr. Erasmus to follow up. Nothing has come back, but I'll just check with Loretta if she can follow up today still. But we have not received anything yet.
Okay, and then can I ask you make a call to the MK party and IFP, so we just know whether they're joining us. The implication of this is that we're probably going to have to defer the first item of the adoption of minutes, and I had wanted to propose an amendment on the agenda as well. Honourable Botlane?
Chairperson, just to inform you that Mr. Ndlela will be late. He'll be here at 11:45. Then we will have a quorum by that time, Chair.
Honourable Subrathi?
Person, thank you. Honorable Matafa is in the precinct. He will be here in a minute.
Okay. 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 But we do need to be advised at some point on the resignation of Honourable Vilskat, because the committee has to be composed of 11 members. So I'm not sure if amongst the small parties they will be fielding another party or what the situation is there, because it's got an implication on our work. All right, thank you. Thank you very much, honourable members, Secretariat. Allow me to greet everybody in the meeting today. My name is Kusela Sangoni Digo. I'm the chairperson of the Portfolio Committee on Communications and Digital Technologies. With me is the committee advisor, Dr. Medupe. I would like, perhaps before we proceed, just so that we get a sense of who is in the room, and then we will move over then to our agenda, the adoption of the agenda by the members. I'm going to start with the members who are on my right. If they could please also just introduce themselves. Honourable Subrathi.
Thank you. My name is Honorable Imran Subrathi. I am representing the African National Congress.
Thank you.
Good morning, honourable members, our officials, and our guests. My name is Mzoledi Mkhaga, representing a member of the committee, representing.
Thank you. You are a member of the committee.
Yeah, member of the committee.
Thank you.
Good morning, Chairperson, and good morning to the meeting. My name is Tsulofelo Bodlani, member of the committee.
Good morning, everyone. My name is Sbongiseni Vilagazi, a member of the committee.
Thank you very much. Honorable Minister, Deputy Minister, you're also very welcomed. Both of you are very famous faces. We won't ask you to introduce yourself. But let me proceed, maybe start at the back, or maybe let me start in the inside row and then we'll move to the back. Over to you, sir.
Good morning all. My name is Kiruben Pelai. I'm a member of the SITA board.
Honorable Chair and members, I'm Luvuyo Keise, member of the SITA board.
Good morning, Chair. Good morning, honorable members. My name is Hilary Chapfua. I'm a forensic accountant and investigator from Cliff Decker Hofmeyer.
Good morning, Chair. Good morning, members. My name is Tendai Jangara. I am a director at CDH. I lead our corporate investigations team.
Good morning, honorable members. Good morning, Chair. My name is Yvonne Mkefa. I'm a director in the Employment Law Department at Cliff Decker Hofmeyer. Thank you.
Chairperson and members, good morning. My name is Simpiwe Tsengwa, the acting MD at SITA.
Good morning, Chairperson, honorable members. My name is Omega Shalembe, Deputy DG, SOE Oversight at DCDT.
Good morning, Chair. Good morning, honorable members, including the honorable members, Minister and the Deputy Minister. My name is Nonkubela Jordan Gyani. I am the Director General at the Department of Communications and Digital Technologies.
Good morning, Ian Stein from the Western Cape Government, Legal Services.
Good morning, Chair and members, Zimbini Hill from SITA Board.
Morning, Chair. Morning, members. My name is Matodzi Rachimbilani, member of the SITA Board. Thank you.
Morning, Chair. Morning, members. My name is Hlangana Nemjali from SITA Legal Services.
Good morning, Chair. My name is Stella Voma, the Deputy Chair of the Board. Thank you.
Good morning, Chair. Good morning, members and Minister and Deputy Minister. My name is Makanu Musidi. I'm the Chairperson of the SITA Board. Thank you.
Good morning, Chairperson and honorable members. My name is Justice Mulafo from Parliament Communications, and my apologies for interrupting.
Good morning, Chair. Good morning, members. My name is Ayanda Klishe, responsible for Parliament at SAPC. Thank you.
Good morning, Chair. Good morning, honorable members, colleagues. My name is Sipoka Zitoto. I'm the researcher for the ANC.
Good morning, Chair. Good morning, honorable members. My name is Zaitun. I'm from the Department of Communications and Digital Technologies.
Good morning, Chair. Good morning, honorable members. My name is Kolisa Mute. I'm from the Ministry.
Chairperson, honourable members, Minister, Deputy Minister, my name is Georgina Marie and I'm Minister Malatsi's Parliamentary Liaison Officer.
Good morning, Chairperson and everybody present. My name is Loretta Lawrence. I'm in the Chairperson's office.
Good morning, Chairperson, members, Minister and Deputy Minister, and everyone present. Igama lam ndinguThembi Nkosi Ngoma, and I'm the second committee secretary. Thank you, Chair.
Thank you. Thank you, everybody. And let me welcome the SITA board. We have not had the pleasure of having met this board, so you are all welcome. Colleagues from Cliff Decker. Now that I think we have a sense of who's in the room, I think we may be able to proceed. We do have the agenda in front of you. The first item on the agenda is the, sorry, before we proceed, can I just check if we have any apologies?
Morning, Chair. We have an apology for Ms. Matthys, Mr. Satoli. I've indicated that Mr. Ndlela will be late, and the Deputy Minister indicated that he would like to leave at 12. Thank you, Chair.
Thank you. We would also like to leave with the Deputy Minister at 12. Agree. Okay. So those are the apologies. Honorable Matafa did say that he's running late as well, so if that could please be noted. The agenda is in front of us, honorable members. Two items on the agenda. The first one is the adoption of the minutes of the 22nd of October and the minutes of the 29th of October. And the second item is the briefing by the department on the report of allegations of irregularities at SITA on the awarding of a 1.2 billion rand tender. Members will remember that the notice of the meeting was amended. And we requested to defer the item on the oversight report to the next meeting on Tuesday. We felt that the report was not yet ready for presentation, so we'll present that on Tuesday. May I have a mover for the adoption of the agenda? Honorable Bogana?
Clarity, Chair, you said you wanted to make an amendment to the agenda. Is this the
Yes,
okay.
yes. It was just, just to bring it forward for noting. Thank you. Could I have a seconder, please? Thank you, Honorable Mkhacha and Honorable Bodlani. Hajindra, can we put up the minutes of the 22nd of October? Okay. Okay, so we will then defer the minutes as the last item. Hopefully we'll have a quorum then. If we could then proceed, Honorable Minister. We had put this item on the program of the committee, requesting a briefing from the department on the allegations of irregularities at SITA on the awarding of a tender to BNC, I think the name of the company is called. This item came to us from the legacy report of the 6th Parliament, where the previous committee chairperson had written to the minister, I think arising out of media reports and a complaint that was received from a service provider alleging that there were irregularities in the award of the tender. As part of the legacy report, this matter obviously was one that the committee felt that it was necessary for us to follow up on. Hence, then we would have written correspondence to yourself, I think as far back as September the 18th, just requesting an update on this matter. We were informed that the report had been finalized and a service provider had been appointed, being Cliff Decker Hofmeyer. Our understanding that was that this was an independent forensic investigation, and hence we then requested that the service provider who had conducted the investigation appears before Parliament to report on the findings of that report. So I will hand over to you to please just lead the presentation of that particular report by Cliff Decker Hofmeyer. Thank you, Minister.
Good morning, Chair, and good morning to everyone in the room. Chair, you'll guide us in terms of the sequencing of how you want the actual presentations being done. I think from our side, upon the request that the committee had made, which was very clear in that the Minister excuse me, the Minister, the board, and CDH should be present for the presentation. We then extended the communication to the board, which is why it's here in the number that it is, and also with CDH being here. And I think for those purposes, because the events leading up to the request and the purpose of why the investigation was initiated is well documented, and it's also clear in your opening remarks. You should then guide in terms of how the sequencing should be done, because the crux of the matter is getting into the report as we understood the request from the chair.
Thank you very much, Honourable Minister. We may take direction from you, but we would not want to create the impression that we're having a hearing. We're not. I think the purpose of the meeting really is to receive the report from CDH. So that is what we are expecting. I think led by yourselves, if you feel that there's any inputs that you would want augmenting the report, perhaps we could consider that. But in terms of sequencing, it's really just you opening and Cliff Decker presenting the report. The members, I think, perhaps then will also be able to guide if any further inputs are requested. I think that when we seek clarity, then the department, the board, and Cliff Decker would be expected to respond to those issues. Thanks, Minister.
Thanks, Chair. Yeah, we didn't canvass the views because we, by convention, the committee then guides how it wants to do things. But I think given that everyone is here, in terms of the request, it will then be useful to then, get into the report. But I'm sure, the presence of the board was also required in that, there should be a contribution at that level. And also from the department, we've got the DG. We also have DDG Shilembe from SOE that oversees the SOE. So everybody who, can speak on the report and the questions that may emanate from it this year. It's just a matter of we can get into the report, but I'm sure there would be, an appetite from either the board or either the directorate to make supplementary or additional inputs into that.
Thank you, Minister. I think we note what you're saying, and I don't think that we would not afford an opportunity to anybody that you directed that they would have to make inputs. But I do want to caution that we are not holding a hearing, so we're not looking for responses to the report. What is being presented, I think, as per the request, is the report. I think the letter from the Portfolio Committee had requested that the Minister investigates these allegations and comes back to report to us. But then I think in the context then of receiving the report, if there are clarifications that are required, we will take that. Okay. Thank you. Thank you. Over to you then, Minister.
Guidance, Chair, then let's get the head of delegation from CDH to get into the report.
Oh my goodness, Honorable Boydlani, please don't kill me. You were right, I did indicate that I needed to make an amendment to the agenda, which was just an update from the committee secretariat on the ICASA process. Thank you. And you asked me yes so nicely, and I said that was it.
And Chair, maybe we can also get an update on the site visit that was planned for December, because we got in conflicting messages in terms of whether Parliament has approved or not approved. So as we make that amendment, please.
Okay, so after the presentation of the report, we'll do those items. Thank you.
Honourable Chair, we'll take your direction in terms of proceeding.
You may proceed, ma'am. Thank you.
Thank you. Honourable Chair and Minister, Deputy Minister and members, thank you very much for the opportunity to present our report. To begin with, we will just give some background into the instruction that we received and then our terms of reference as well. We were briefed and instructed by SITA to look into the matter of a Western Cape Education Department services tender, which was named RFB 2556-2022. We received our brief and instruction on the 1st of August 2023. In terms of our instruction, CDH was asked to respond by way of investigation to a matter that had been brought to the Portfolio Committee, and thereafter an instruction which was given to the Minister to conduct an investigation into allegation of procurement irregularities and a specific irregularity on the adjudication of local content as part of the tender. We received the instruction from SITA and officials of SITA, specifically from the board of SITA. And in receiving this instruction, we were given terms of reference to look broadly into the procurement process, which had led to the awarding or the recommendation to award RFB 2556-2022. Having received this instruction, we met with the officials at SITA to be briefed on the matter. In our briefing with the SITA officials, we were given a full scope of understanding of the matter that we needed to look into. Now, as I had said, the allegation was based on one specific matter, which was part of the procurement process. But in terms of the instruction that we received, we were given broader terms to look at the full procurement process. And in looking at the full procurement process, we were to take into consideration the applicable legislation, applicable regulations, and the applicable officials in that procurement process. We were also requested to put in a request for everything that we required for the investigation. So having had the meeting on the 1st of August and received our briefing, we then proceeded to do an evaluation of the information that was before us. We were then provided with the opportunity to work with one SITA official who was our point of contact, Mr. Dave Boucher. And he was the person that we interacted with in terms of receiving all of the information that we required and contacting the relevant persons. So we went through a process of understanding what the tender process was. We received documentation pertaining to the tender process. We also denoted the relevant officials through the process. And just to give context to this matter, this was an agency transaction. The Western Cape government, and specifically the Western Cape Education Department, required allowance services and had then gone to SITA to go through an agency transaction to go through the procurement process. So we were then to deal with SITA officials, but also with the Western Cape Education Department and some Western Cape government officials as well. So in the scope of requesting the information that we required, we looked at SITA specifically as the agency that was dealing with the tender and the procurement process. We also looked broadly to the Western Cape Education Department to also interact with the officials who we needed to interact with there. And then we also then looked at our external parties. Now, external parties for this matter were the bidders who submitted bids specifically for this tender. So we were given the latitude to engage with all persons that we deemed relevant to this matter. And again, our point of contact in beginning our investigation was Mr. Dave Boucher. And what we did was go through a process of a document and information request. We officially requested all of the information that pertained to the tender. We requested all of the persons that were involved in the tender for purposes of conducting interviews. So having begun the process on the 1st of August, by the 8th of August, we had received the documents that we needed to make our preliminary beginning of the investigation process. We went through a process of analyzing the documents that were before us, requesting further documents. We also went through a process of scheduling interviews with the relevant persons who we needed to engage with. And what we can say from the beginning of the process, having been instructed by SITA and having gone through the process of requesting information and requesting to engage with relevant persons, we received full cooperation in that regard from all of the relevant persons who we required to engage with, and also received all of the documentation that was available, either within SITA or with external parties. That being when we engaged with the Western Cape Education Department or officials of the Western Cape government, we received all of the documentation that we needed to deal with. And this speaks to the integrity of our investigation. We can certify that in going through our investigation, we had all of the information that we required from a documentary perspective, which allowed us to conduct a full analysis of the procurement process. And we'll go through the details just in summary of that procurement process. Now, having received all of the information that we required, I'll just set out the methodology that we went through, which I've touched on. We went through a process of analyzing documents. So our analysis of documents was based on documents received in physical form. We also received documents electronically, so those would be documents that are stored on laptops and on servers. We also had access in terms of digital forensics to go into documents that were stored on specific devices that pertained to officials within the SITA environment, and any email communications that pertained to the matter that we looked at. So that was the process in terms of receiving information and accessing information, and then going on to analyze the information. Now, as a process of analyzing, what that did in terms of the process and our investigation was just to give us the full scope of the procurement process. And I'm just going to ask Hilary to run through what we established as we went through that analysis, just in terms of the procurement process that was undertaken. And just to understand that, again, as I said, this was an agency transaction, so we had two parties involved here. It was the SITA officials working together with the Western Cape officials, as this was for the benefit of the Western Cape.
Thank you, Honorable Chair. I'll just go through the procurement process that was undertaken by SITA. So upon receiving the business case from the Western Cape Education Department, the business case was approved, and upon approval of the business case, they undertook a process of coming up with the bid specifications. A bid specification committee was constituted of members mostly from the Western Cape Education Department, and members from SITA were just there as coordinators. They came up with the specifications for the particular services that they needed, and the specifications were approved by the Executive Bid Adjudication Committee. Upon approval of the specifications were then published in accordance with the prescripts, the legislative prescripts. What happened after the publishing of the specifications, a compulsory briefing session was also held with all the prospective bidders. After that, questions were asked and questions were responded to. After the compulsory briefing session, the bids were opened to the bidders for them to submit the bids. It then came to a time when the bids were supposed to be closed, and the time to close the bids came to around 8 August 2022. The bids were closed, and then 11 bidders submitted bids from that process. They undertook a process of evaluating the bids. So they evaluated the bids as a committee, but the committee again constituted of members both from the Western Cape Education Department and from SITA. Members from SITA, it is very important to note, in that evaluation committee, they were just there again as coordinators. The actual evaluation was done by members of the Western Cape Education Department. Upon completing the process of evaluation, a submission was then made to the Executive Bid Adjudication Committee to evaluate the evaluation process that was conducted by the Western Cape Education officials. What happened after that, the Executive Bid Adjudication Committee submitted the evaluation again to the bid procurement committee. And the bid procurement committee, it was a bit of a back and forth due to issues that were raised after a PKF report as part of the probity audit it had issues in terms of the evaluation. After that, the matter was handed over to the board, and again, it was a back and forth, and it is something that we will go through the process as we go through the discussion. Thank you, Tendai.
Thank you. So as part of our investigation process, having been given the instruction which emanated from an allegation that had been raised with the portfolio committee, and with us having the latitude to look at the procurement process, we went through a very rigorous process of looking through the procurement, looking at the evaluation. We went through a step-by-step of how decisions had been made as the evaluation process went about to get to the point of getting to recommend one of the bidders, namely BNC, as the recommended successful bidder in this process. Through our process, we established 4 irregularities, and these irregularities were based on our analysis of the process that was undertaken. And again, just to stress that we looked at the process from its initiation until its completion at the point where a recommendation to award was made. And we were looking specifically, as I said, at all of the parties involved and the roles that they played. Now, when it came to the first irregularity that we denote here, alternative solution and 2 pricing options, when a briefing session was held on the 2nd of June 2023, a question came up from the prospective bidders who were in that compulsory briefing session. This question pertained to the solution that was in place within the Western Cape Land Services at the time. At the time of the tender renewal, and I must just explain that the services were actually in place, and this was a new tender being run to continue the services for land tender services within the Western Cape. So there was a solution in place at the time, and it is called the Xyrus solution. When the tender briefing, compulsory briefing session was held, question number 12 in that briefing session was whether the bidders had to also provide a Xyrus solution or if they had the latitude to provide a different solution. And the words that were used in that briefing session became very important in terms of how the tender progressed and how it was eventually recommended for award. The issue of an alternative solution became contentious because the understanding of what was being asked in that briefing session was whether people needed to, or the bidders needed to also provide a solution which was Xyrus, which was the solution that was in place at the time, or whether they could provide an alternative solution, with the word alternative meaning something that is comparable to Xyrus, something that would be interoperable with Xyrus and would not require a complete system change. The response that was given to the question was that the bidders had the option to provide an alternative or an alternate solution. How this then culminated in terms of the bidding process was that the bidders, 10 out of the 11 bidders, from our understanding, then provided a specific solution, so one response. One bidder was disqualified at the first stage, which was the pre-administration stage. They did not make it through. So we had 10 bidders out of the 11 who then progressed and went through to the next stages of evaluation, through the mandatory technical stages, the functional technical stages as well. Now, as a result of having had this question, one bidder then provided 2 pricing options in one bid. Now, the practical implication of that is that when we looked at what the bidder had submitted, they had submitted, for all intents and purposes, one bid set of documents which pertained to their bid, except at the pricing stage, When it got to the pricing stage, they then had two options that they presented to the evaluators. So their tender at pricing contained two options that could be considered. One option was the Xyris solution, which was a solution that had been in place up to the point where this tender was being put forward for consideration. They then also included a Huawei option, but the options were all in one bid proposal. It was only at the pricing stage that they had separate documents. Now, the practical implication of this, first of all, was that the split only happened at the pricing solution stage. And then the second implication of this, when we evaluated with the process, was that because of how the tender evaluation process is structured, and the different committees that sit and evaluate the different stages, it was only the pricing solution, which was at stage 4 of the evaluation process, that had the insight into the fact that this bidder had submitted two pricing options. The previous committees that sat and evaluated from the beginning mandatory, the admin stage and the mandatory technical stage were not privy to the fact that this bidder had put in two pricing options. It only became known at the pricing evaluation stage. This was the only bidder that provided two pricing options in one bid. We went through a process of analyzing and reviewing and going through a process of understanding bid evaluations and how bidders submit their options and submit their bids for evaluation. We could not find precedent that speaks to a bidder providing two pricing solutions or two pricing options in one bid proposal. And what gave evidence to this as well is that there is a form, an SBD 3.2 form, on which a bidder must stipulate what their firm price for a bid is. We found that because this bidder had two pricing options, they were incapable of then saying what their firm price was. And as a result of that, they did not comply with SBD 3.1, which is one of the very important and key forms that have to be submitted by a bidder when they provide their bids and have to be clear in terms of what their options were. We found that going through our interviews, as we said, we spoke to all of the persons who were involved in the evaluation process, and the issue of two pricing options was contentious from the time it became known. So starting with the price evaluation committee, moving on to the board procurement committee, and then going on to the board, in terms of the discomfort that this issue caused, and with the understanding that in a normal tender, and how bidders would submit, is that they would make it clear what it is that they are proposing and how much it would cost. Now, in this situation, there was no clarity because this bidder had submitted two pricing options in one proposal. The result of this process was that the irregularity of having the two pricing options flowed through, as I said, from the pricing committee, which itself said it was satisfied that there was no irregularity in terms of having the two pricing options, with then proceeding, and I'll just jump to the board procurement committee, where there was discussion around whether this was a regular practice and something which was acceptable. When the matter came to the board and the board had to make a decision in terms of who to recommend, and had been provided with BNC option 1 in terms of its pricing as the recommended person or bidder to be submitted to the Western Cape, there again was discomfort in terms of the fact that there had been two pricing options. The board, in looking at this issue, felt it necessary to even proceed to a request for an opinion. They asked for legal risk and audit advice based on the fact that this was something that was irregular. We found that based on the decision that came, so the opinion, the legal opinion, which was submitted to the board then felt that it was satisfied with the result of that opinion and then proceeded to go through the process of recommendation. Now, important points in terms of our analysis of the situation is, from a practical tendering process, we went through, again, as I said, researching to see if this is a normal or a regular practice. We established that it is not. We also established that in terms of this RFP itself, there was nothing explicit that said to the bidders they could provide alternative solution in how it was then interpreted here to mean that they could provide two pricing options. In our interviews with the bidders, we questioned and asked them if this is what they had understood. What came through was that the bidders had not taken this to mean that they could provide different pricing solutions within one bid. And one bidder specifically said to us, had we known that we could do that and we had the option, we also would have proceeded to provide different pricing options within that one bid. So we were satisfied, having gone through the investigation and understood how this had played out, that what was meant by alternative solution was an alternative to the Xyrus solution, providing a solution that could also work as Xyrus works, and not the interpretation taken by BNC, the bidder, to mean that they could then provide two pricing options. And we believe, and having gone through this process, that by providing those two pricing options and not even being able to then complete the SBD 3.1 form, this created an irregularity that fatally flawed this process. Chair, I will move on to the second irregularity. Our second irregularity is local content, and this is the irregularity that actually prompted the report to Parliament and then the instruction to the Minister to investigate, as one bidder became aware of the fact that there were irregularities in how local content was evaluated as part of the process, the bidding process and the evaluation process. Now, according to National Treasury instructions, there is a prescribed minimum on certain products when it comes to bidders putting their bids together, and there is a prescribed minimum threshold in terms of local content and local products that must be used or put forward as part of the services that will be provided by the bidders. In this tender specifically, what was designated were electrical cables, locally made electrical cables, and these needed to meet the threshold of 90%. So what this meant was that when the bidders were preparing their bids, they needed to demonstrate that as part of the services they would provide and the products therein, there would be use of electrical cables which were made in South Africa, and of the total component of those electrical cables, 90% had to be locally manufactured. There is a specific way that the forms that are required for responding to this matter have to be completed, and in completing those forms, it is incumbent on the bidders to ensure that they have completed the form correctly, and having completed the form correctly, it is then incumbent on the evaluators to ensure that they can see that the bidders have met the threshold of 90%. Through our investigation process, we then established that when the bidders completed these forms, which are at SBD 6.2, and have specific annexures, with Annexure C being the relevant one for this specific requirement, 3 of the 10 bidders responded to this correctly. So there were 3 bidders that went through the process and correctly responded to this requirement. 7 bidders did not respond correctly to this. In those, there was 1 who did not respond at all. The rest of the bidders included the electrical cables as part of the overall products that they were going to provide as part of their services. Now, what this meant is that they had to go through a calculation And having included these electrical cables in their overall calculation, which included imported products, they then had a lower threshold than the 90%. So 2 bidders then had a lower threshold. Other bidders still declared an over 90% local electrical cable provision, but had not completed the form correctly. Now, the key to this irregularity is the completion of the form, and if you can still bear in mind that 3 bidders actually responded correctly. Having gone through the process of evaluation, the evaluating committee then recognized that what some of these bidders had done was include the electrical cables as part of their overall calculation, and as a result, the calculation was not correct. The committee then went through a process of extracting the correct information themselves, and as a result, then came to the conclusion that more than 3 bidders had met this threshold. In our investigation process, we then engaged with the relevant parties, the committee that sat and went through the process of doing this, and more importantly, for this one, also engaged the internal audit probity team that had gone through an analysis of this procurement process. The probity team had gone through the process of evaluating what the evaluation team, the adjudication team did, which is extracting that information. And in the internal audit report, the original internal audit report had then stipulated that it was not correct for the team evaluation committee to have gone through the process of extracting information from forms that had not been completed correctly. And as a result of that, they denoted that the tender and the evaluation process was then tainted because of that action that had been taken by the committee of going in and extracting information. They had denoted this as causing this tender to then be non-compliant in terms of what was required for this form. We also engaged with the officials who went through the process of actually going through and extracting the information, and the explanation that was given was that in their evaluation, they believed that because they could see what, or they believed that they could interpret what the bidders meant, they went through the process of extracting. Our investigation found that it is not the responsibility of any evaluation committee to go in and extract information which has not been clearly stipulated by a bidder. To do so renders a process unfair because there is no transparency to the rest of the bidders in terms of how evaluation is happening. What the RFB and what the tender stipulated was that this form had to be completed and it had to be completed correctly. Failure to complete it correctly would then render the bid then non-compliant. It could not be that the evaluation committee would then take it upon itself to go through a process of extracting information. So based on that, we had the finding that this was an irregular practice, and what really solidified this for us is that, and I'll come back to, 3 bidders actually responded to this correctly. So we found that there was no vagueness when it came to what was required here. It was clear in terms of the stipulation. We also found that had there been a concern in terms of what the evaluating committee was seeing in front of it, they had open to them the option of actually contacting the bidders for clarification. Our law and our processes allow for clients and prospective clients of services to go back to bidders and to seek clarification on any bids that have been submitted. We do not know why this option was not was not utilized by SITA and by the client at the time, being the Western Cape, and why this process of extracting information was used instead. And we then established that the use of the system, which they called the hybrid model, and which they said was a use of substance over form, so going in and looking at what was intended versus what was written, was not an acceptable practice, as it goes against the clear principles of competitive, transparent, and regular fairness practices in terms of procurement. I will move on to the third irregularity, and this pertained to a bidder called Dimension Data. As part of stipulating the structures that were bidding, the bidders had to be clear in terms of who was actually bidding to provide the services. They then had to stipulate the holders of the required certifications that would be utilized and were necessary for the provision of these services. Dimension Data has a parent company called NTT, and what was established through the procurement process was that one of the certifications, so the Microsoft Gold certification certificate, was in the name of NTT, and as a result, Dimension Data was disqualified because it was then stipulated that the certificate did not pertain to Dimension Data. Through our engagement process and analyzing the documents, we found that in the submission that Dimension Data had made, they actually did stipulate that NTT is the parent company. And as a result of NTT being the parent company, the certifications which applied to NTT would then apply to Dimension Data as well. They stipulated that in their documents. So from the first page, you could see the relationship that existed between NTT and Dimension Data, and through the documents in page 6 of how they explained the relationship, it was made clear as well. We found that having gone through the documents and how the relationship was stipulated, the procurement, the adjudication committee's decision, which they based on the fact that NTT was not part of the bidding structure, was irregular, and we found that the disqualification was not correct. It was not a correct decision because Dimension Data had stipulated that NTT is its parent company, and as a result, there was a clear relationship between the bidder, which was Dimension Data, and the parent company NTT that held the Microsoft Gold certification. Again, this is a situation where if clarity was required, it was open to those who were going through the evaluation system to require SITA to go back to the bidder to request for clarity, just in terms of this relationship. What was, I think, also of importance is we went through an interview with Dimension Data. Dimension Data is a SITA service provider. They do provide services. When a previous tender had been run for this specific service, which was RFB 2446-2021, which was eventually cancelled, Dimension Data had actually come out as the successful bidder in that, but that process did not continue because a material irregularity was picked up in that process. So that tender was cancelled. But at the time, Dimension Data had actually emerged as the successful bidder. So in our analysis and evaluation, we then found that this disqualification was not correct. It was not a correct decision that was made by the evaluation committee. Our fourth irregularity that we identified through the process was at the decision-making stage, when this matter then came before the SITA board. Now, in terms of the delegation of authority, any provision, any tenders of the value of 50 million and above must be approved by the SITA board. And we found that having gone through the evaluation process, documents were then prepared for the SITA board to consider. The recommendation to the recommendation to be communicated to the Western Cape government to recommend the award of the tender to BNC, option 1, which was the split from the 2 pricing options. We found that a special meeting was held on the 2nd of March, and the board, again, as I cited before, also had discomfort in terms of the 2 pricing options, and as I said, then requested for an opinion which clarified legal risk and audit options before they could proceed with a decision on this matter. And it was resolved at that board meeting that the decision would then be made via round robin. So the board would not convene again, and this was as a result of time pressure. So the tender process had been extended. And just as Hilary had explained, that they went through advertising the tender, there were 2 extensions of the tender time during that time. So the tender went out on the 24th of May. And the original closing date was the 18th of August. It eventually closed on the 24th of August. So there had been a time lag. And again, this was a tender that had initially been run in 2021 and had not come to a successful end. So the contract at the time had been extended. So there was time pressure in terms of ensuring that this tender could come to a conclusion. And as a result of this, the decision was made to evaluate, to go through, obtain an opinion, and then make a decision via round robin. And what the requirement had been was that it go through the process. Once the opinion had been received from council, it would then go back to the EBAC. It was supposed to also go back to BPC, the Board Procurement Committee, and then go through the round robin process. On the 29th of March, each board member received a pack of information. So this was post the opinion having been obtained, the legal opinion having been obtained. Each board member received a pack for the round robin decision. Now, what is important to bear in mind is that these packs were sent to the board members individually. There was no circulated document, which would then give the board members sight of the decisions that were made by other members. The round robin process was undertaken, and of the round robin process, 11 members responded, and 8 out of 14 members responded in favor and responded correctly. Now, how we did that was we went through an evaluation system of the actual documents pertaining to the round robin process. And we found that in terms of responding to the round robin, there was one completion of a form that had a signature but no stipulation in favor, not in favor, or abstaining. There was one which required the matter to revert to the BPC before it went back to the board. So consideration of the opinion at BPC before it went to the board. Our investigation established that this process did not happen, and the board member had actually stipulated on their form that they were in favor, but with the condition that this matter had gone through BPC and BPC had approved it. So on our evaluation and looking at the process, we found that there were 8 board members who voted via round robin in favor of the process. So this was 8 out of 14. There was one board member who was not in favor and gave an explanation of why she was not in favor of it. And this was based on the fact that there was an understanding that the 2 pricing option had not been responded to the satisfaction of her being able to say the process was then correct. So she voted against. There were 3 members who did not respond at all. So we then went through a process of looking at what was then required for approval in terms of the MOI of SITA, and looking also at the Companies Act and what this process needed to go through. And we established that in going through this process, only 57% of the board members had voted in favor of this round robin resolution. And as a result, what threshold needed to be met was 70% as per the MOI. We then established that an incorrect tallying of the votes to include a positive vote where one member had not indicated if they were in favor, not in favor, or against, or abstained, and also the member who had given a conditional vote actually did not meet the threshold when it came to the MOI. And this decision was made, and a meeting was then held on the 30th of May, and this was a sitting of the board members where the decision which was made via round robin was then ratified. We established that because...
Sorry, Madam, I'm so sorry to interrupt you. Our latecomers have a point of order.
Latecomers are going to contribute here. Good morning to everyone, and my apologies. We just had other business to also adhere to. Chairperson, I just want to know, and please excuse me for interjecting your presentation. I want to know the following. This report that is being presented here is as it pertains to a board or during their oversight. Now, I want to know, are those board members present with us here? Is that same board present with us here that is being reported?
Okay.
I'm just trying to get some clarity.
I will forgive the interjection and welcome Honorable Ndlela Shongwe, Honorable Member, and Honorable Matafa, who were not here at the start of the presentation. We did go through introductions right at the beginning. The board of SITA is in the meeting. Presenting is Cliff Decker-Hofmeyer. The department, obviously, and SITA, led by the minister and the deputy minister, are here, as is the DG and senior executives. Yes. And then can we allow Cliff Decker to finish the presentation? They're almost done. And then we can then go into the discussions. You want to raise another point, Honorable Ndlela?
Yes, I'd like to raise another point. When we refer to a board, there's been two different boards to date at SITA. Which board is it that's here, Minister? Through you, Chairperson.
Let me allow Honorable Bodlani to come in before I respond. Honorable Bodlani?
And I'll say the following, sorry, Honorable Bodlani. My concern is I don't think it would be proper for a board to be present whose report reflects or is, in fact, giving insight of how they presided over the entity. I'm just raising it. I mean, to me, it would be a bit of a concern that an independent entity just giving a report and giving us feedback as the committee over a board that presided over the same, what would be some transgressions, be present with us as they're presenting an independent report. That's just my observation. I don't think it's proper. Thank you.
Honorable Bodlani?
Chair, I'm tempted to say maybe you must respond to the last part of Honorable Ndlela's comment before I make my comment, because mine was to rule him out of order. But perhaps if you answer that one, it will also inform my position in how I want to reflect on what he has just said.
Is that in order with you, Honorable Subrathi? Or would you want to come in?
Chairperson, thank you. I think I'm covered by Honorable Bodlani. Safe to mention that I think in the light of transparency and accountability, I think it's imperative for us. The Portfolio Committee had asked for the board to be here. And we need to examine and get accountability from the board as well. So I think it's important for them to be here. We're in a transparent process. I don't think having the board to be excluded from this conversation contributes to transparency. So I fully support the decision of the PC to invite the board to be present here, and they should be present. Thank you.
Okay, maybe let me come in. I see your hand, Honourable Member. I'll come in. And we spoke to this matter right at the
Chair.
beginning. I'll come to you. Allow me.
I just want you, when you respond, it's one issue, Chair. I just want to add so that you don't have to come back to me on the same issue. My apologies.
Are you adding to the point that we are discussing?
Yes, Chair. No, just Chair, because what Honourable Ndlela maybe is trying to say is that because we are not going to need a response on this report. This is a report that we want as a committee, as raw as it is, because we want the status of the irregularities. So the board is not here to respond to anything. So that's what we are trying to say, that they shouldn't be here because they're not going to give answers to anything. This is a report, an independent report that we want as information as a committee. That's all that we want.
Okay. Honourable members, when we started the presentation, we had a discussion on this matter, even though it may have not been framed how you are presenting it. We invited the minister to lead the delegation and obviously to set the context for the presentation. One thing that we said very clearly was that this was not a hearing. So we are not here to ask for what is then the view of the board or even SITA executives or the department. The Portfolio Committee had requested an investigation be undertaken. Cliff Decker was appointed to undertake that investigation, and we want the report. So our report is the one that's being presented by Cliff Decker. Now, in terms of the invitation that was sent, we invited the role players because if we felt that there's any clarities that we want, we would do so. And that was the context of the discussion right at the beginning. So we are not expecting anybody to be responding, defending this report. We are receiving the report today and obviously following up on the request that we had made to the Minister for this investigation.
Chair, I think with what you are telling us, it therefore says that we are almost halfway through the presentation. And with all due respect, the members, and Honourable Ndlela specifically did notify the meeting that he would be arriving late. But these things where you did tell us before coming to the meeting how this would happen. We also had a notice of the meeting which told us what would be happening. So I think it is improper as a portfolio committee to be holding everybody up on what should have been a housekeeping matter. If these issues perhaps would have been raised before coming to the meeting, it would have assisted. But at this point, Chair, I urge you to please rule Honourable Ndlela and the Honourable Member, I'm sorry I do not know his name, out of order because they are disrupting the flow of the meeting.
Honourable Ndlela, I want to please plead with you that we don't have a dialogue on this matter. I want to propose we allow Cliff Decker to complete. They are almost done their presentation. If there are issues in terms of who you think must participate or not participate, and they come up in the deliberations, then we will deal with it.
Bodlani is in no place to make recommendations of such. Honourable Mrs. Manawa Helenzil, please. All I'm saying is there's nothing stopping me from raising an issue.
Honourable
If I'm
Ndlela.
concerned, Chairperson, about something that I believe could be of conflict here, where there's a presentation that's being made, I'm not going to be told by Bodlani as to whether I'm correct or
Honourable
not.
Ndlela.
So I want that to be on record. Thank you.
Honourable Ndlela, please withdraw the reference that you made to Honourable Bodlani.
I draw.
Which one are you withdrawing, Honourable Ndlela? Honourable members, I'm begging you, please.
I withdraw.
think we
I withdraw.
understand
Let's continue.
the
It's
issue.
fine. I withdraw.
I do apologize. Please proceed, Madam.
Thank you, Chair. Chair, I was explaining that after the round-robin process had been taken place, there was a lack of meeting the threshold, minimum threshold in terms of the required votes. And at the time that this process was completed, which was the round-robin, the decision was inoperative until ratified at a sitting of the board. The board then sat at the end of May. and at that sitting then went through the process of ratifying the decision. Now, what's important to note is that in ratifying the decision, this was ratifying a decision that had not been correct at the time that it had been taken. So it was not a decision that then had the desired authority or the desired, what would have been the desired result. But between the time of taking the round robin decision and there being the understanding or the belief that this had been done correctly and had met the minimum threshold, the decision to recommend that BNC be the successful bidder was communicated to the Western Cape. So the Western Cape obviously was not aware of what was happening. These are two separate processes. And I think the importance for us was to just understand what the impact of this incorrect decision was on the rest of this procurement process. So it was communicated to the Western Cape the day, just shortly after the round robin process. It was then communicated by SITA to the Western Cape that BNC, with its option 1, was the recommended successful bidder. And the decision in terms of actually awarding sat with the Western Cape. So it wasn't SITA that was awarding. SITA was making the recommendation, having gone through that process. The Western Cape then wrote back to SITA and acknowledged that SITA had communicated this recommendation and accepted that recommendation. Our understanding is that the Western Cape then proceeded to act based on the decision that had been communicated by SITA. The sitting again, now coming back to our ratification process, we found that the ratification of the decision that was made was inoperative in the time that it was communicated to the Western Cape. It only became operative on the 30th of May when the board actually had a sitting. So in communicating that to the Western Cape, what was communicated was actually an inoperative decision. So the process was incomplete in the time that it was communicated to the Western Cape. And the Western Cape had gone forward and acknowledged and then acted on that information. So in terms of this irregularity, we found that SITA did not comply with its own governance processes. And this is of particular importance because the Western Cape was dependent on SITA in terms of coming to a correct conclusion of this procurement process, so running it correctly, and then also coming to a correct conclusion. Western Cape acted on the decisions that were made by SITA or were communicated by SITA. So in summary, we found 4 irregularities, having gone through a very rigorous process of analyzing the full procurement process. We tested this factually. We looked at it from a legislative perspective, and we looked at how procurement processes are run as per the regulations that are provided within our systems. Now, based on this analysis and the 4 irregularities that we established, we then communicated to SITA what our findings were. And we then, having made these 4 irregularities clear, then presented to SITA that it was within its authority to reevaluate the decision which had been made to recommend the awarding of the tender to BNC. And it is important to just make it clear that in this, in our communication, in our recommendations, we was making it clear to SITA that having gone through this process, it then was incumbent upon them to see how they acted on our recommendations. So the first was to consider going through reevaluating its decision as communicated to the Western Cape, communicating to the Western Cape government as well that these irregularities had been established through this investigation process. And then because of the gravity and the materiality of these findings or these irregularities, that there be a decision made in terms of going through a self-review process to now reevaluate the irregularities that have been found and to look at that, to reconsider the tender process and to establish and make clear that in getting to the process of recommending this award, as had been done by SITA, there were material irregularities that had been established. We also looked at the actions of the board. We engaged with the board. We went through interview processes with the board members who made themselves available to us. Not all of the board members made themselves available to us. Through that process, we had concerns in terms of the knowledge that the board members had or displayed to us in our engagement. We also then stipulated that in our report, just in terms of the understanding of the subject matter and how that came across, evaluating board members' attendance of meetings, which were very crucial at the time. And through that process, we also made the recommendation in terms of what we found, having gone through the process of evaluating how the board was involved in this process. We also then recommended specific actions, and I'll come to the specific actions of people who were involved in this matter. We recommended that the persons who were involved in the decision for local content, who were specifically the supply chain management, Center of Excellence, legal services, and ultimately the decision coming to the board, be held accountable in terms of that decision with local content. The two pricing options we found was what had necessitated the round-robin process. We found that that round-robin process was irregular. We then also recommended that in terms of that irregularity of the round-robin process, the company secretariat function be held accountable for same, because they had to go through the process of ensuring that the votes were tallied correctly and that the governance processes were met. We then found that the communication to the Western Cape Education Department was something that had been done before the decision that was made had become operative, and as a result, the Western Cape had acted on that, and accountability there rested with the company secretariat and the supply chain management. Our last recommendation spoke to ambiguity. So we found that the genesis of the two pricing option confusion happened in the briefing session, where the word alternative was used. So our last recommendation was that when bids are drafted, when specifications are drafted, they must be done in a manner that is unambiguous and is clear. And that is something that even the SITA officials, when we conducted interviews, had conceded to and had committed to ensuring would be done when they went to the next processes. They didn't want to necessarily concede it for this one, even though we found that it was very clear that there was ambiguity, but it's something they said they would look at for future tenders. So in conclusion on this specifically, and I'll hand over to Yvonne to speak about consequence management, we found, having gone through our investigation process, that there were 4 very clear material irregularities. These are irregularities that had an adverse effect on the procurement process, and as a result, tendered the procurement process and the finalization thereof unfair. It lacked transparency and ultimately lacked fairness in terms of the bidders who participated in this process. Thank you, Chair. I'll hand over to Yvonne to speak on consequence management.
Thank you. Thank you very much, Tendai. You may proceed, Madam.
Good morning, Chair, and to honorable members. The second part of the presentation is on consequence management. The 2 parts that I'll giving feedback and progress report on is on the internal processes, which is the suspensions and disciplinary hearings, of the people that were stated in the recommendation, or the department specifically, and how we went about identifying the people that needed to be held accountable. And the second part is the external processes that flowed from the internal processes. And that is on the unfair labor practice, which is the unfair suspensions that were referred to by the two senior leaders in the organization. The approach
Sorry,
that I'm going to take...
My apologies. I don't know if members have had an opportunity to see this. I know I'm seeing it for the first time. Is this now part of the brief that you were given by SITA for the investigation?
As a flow from the investigation, there was a recommendation for consequence management, and that was referred to the Employment Department of CDH to support SITA on it.
Okay, so you were asked to do an
specifically for this
investigation
particular.
and then follow through with consequence management. So that was your entire brief.
Indeed, Chair.
Okay, Honorable Ndlela, I see your hand is up.
No, thank you, Chairperson. As you said, I think this will be our first time having a stint at this, because we've not seen it. We don't know what the contents of this presentation are. Again, I guess I'd like to raise the same issue. I'm just concerned that, we are not being given an opportunity independently to engage in this report in the presence of the board. I think it's also unfair on them, to be honest, that, we preside over this presentation, because I quite honestly believe it's in conflict. The situation as it is, I'm very concerned about it. These are pertinent issues. I mean, I was looking at some of the recommendations that were made there. Material breaches. I'm concerned, Chairperson. That's all I'm saying. And again, as you'll recall, I proposed that whilst we are in Johannesburg next week, we could engage with the SITA board over, the outcomes of this report. That's my recommendation. I just feel it's incorrect to have them present. That's all.
Okay. I hear you, Honorable Ndlela, and the first challenge that I think I have with the issue that you're raising is that meetings of the portfolio committee are open anyway. And I think what you are speaking to is the issue of participation, which I said that we could always look at. I've got a different problem around this report. Its presentation, given also the terms of reference, because I think we would have asked the question, I mean, I haven't seen it, I don't know what you're going to present, but we would have asked the question that, can somebody investigate, conclude a report, implement consequence management, and end in one? But if that was the brief that was given and that is what is being presented, I suppose we can always come to that issue. I don't know if members understand the point that I'm trying to raise. But nonetheless, if that was the brief that was given to you, it's fine. Honorable Ndlela, with your permission, once we finish the presentation, because this is the last, and I think when members are also engaging, we've noted what you're saying about the participation of people who are the subject of the report, and I think that will then allow members to reflect on that when we are engaging with the report.
If I may, if we do continue in the way that you're proposing, Chairperson, then I guess since they are here as the board, maybe we should then at the end engage them.
We are not running a hearing, Honorable Ndlela. If there's issues of clarity, we can engage issues of clarity, but we are not running a hearing.
On issues of clarity?
Thank you,
yes,
sir.
that's what I'm referring to. Issues of clarity based on what's presented.
Thank you, sir. Madam Yvonne, sorry, I was saying that I don't, most we take ourselves very seriously in Parliament, so we always refer to people formally. Miss Mang Mang, now I've got Madam Tendai, Madam Yvonne. I've asked for the surnames of the delegation, so we may refer to you appropriately. Please proceed, ma'am.
Thanks, Chair. I think I must just bring clarity on the issue of the instruction in the terms of reference. When Ms. Jangara's department was approached, it was to investigate the tender. And subsequently to that, there was a board resolution that had looked at the recommendations, and part of those recommendations said there needs to be consequence management. And the department, which is the employment department of Cliff Decker, was then engaged and instructed separately to deal with that aspect. That's the context, Chair. As I stated, that there were 2 items or 2 processes that I'm going to give feedback on, flowing from the outcome of the investigation. The first part is what I've just explained, is that the employment department of Cliff Decker Hofmeyr was then instructed to implement one of the recommendations from the board resolution that was undertaken on the 31st of October, and it read that to follow SITA processes regarding consequence management. As a result of, or pursuant to that, in November 2023, 2 executives were suspended, which was the acting company secretary, and he also holds a substantive role, which is the head of legal services, and Mr. Kenneth Pillay, who's the supply management executive. And in February, they were both charged, and they were jointly charged and invited to a pre-hearing meeting in March, but the first hearing was scheduled.
Chair.
Honorable Matafa.
Thank you very much, Chair. My apologies. Greetings to everyone in the House. Chair, I'm just wondering, will you be finished with this presentation after it is done? My question is premised on the fact that if you look at the screen, there are certain words that do not come through on the presentation. So as the presenter speaks, it seems as if she is reading words that do not exist in the presentation. So I'm just worried. I think it's better that we are finished with it so that there's consistency in what we receive from what we hear and what we have as official correspondence of the committee. Thank you, Chair.
Thank you. Can I just check with the Secretariat? Hajira, do you have this presentation? Okay, so is that matter being attended to? All right. And then as soon as you receive it, if you could send to the members, please. Noted. Thank you, Honorable Matafa. Yes, ma'am.
Thanks, Chair. I was actually trying to be brief, but I'm happy to read word for word. So in November 2023, SITA placed Mr. Tendai Vincent Mpapuli, and who was the then acting company secretary and the head of legal services, and Mr. Kenneth Pillay, who is the supply chain management executive. And in February, both Mr. Pillay and Mr. Mpapuli were served with a joint charge sheet and invited to attend a pre-hearing meeting, which was scheduled in March 2024. The disciplinary hearing was set down on the 5th and 6th of May. However, this hearing was postponed, and again, then the matter was then rescheduled. However, in the intervening process period, the matters were separated. They were no longer going to be charged jointly, particularly because Mr. Mpapuli's charge sheet was amended. And in June, Mr. Pillay's disciplinary hearing was scheduled for on the 10th and the 11th of June, and the investigators' evidence was led and would have been continued and when the meeting reconvened. Mr. Mpapuli's hearing was then scheduled for the 13th and the 14th of June 2024. On the 14th of June, the chairperson made a jurisdictional ruling, finding that he does not have authority to preside over Mpapuli's hearing as the managing director. Then the acting managing director didn't have the authority to charge Mr. Mpapuli in his capacity as the acting company secretary, where due to the fact that the delegation of authority state that it is the board that has the responsibility for any of the company secretary's career incidents. The chairperson then directed the SITA to regularize and furnish Mr. Mpapuli with the requisite authority. And in September 2024, Mpapuli's charge sheet was supplemented to incorporate based on the Senior Counsel's advice, and it was then reissued. Pillay and Mr. Mpapuli's hearing were reconvened on 16 September and 19 September, respectively. The issue of the authority of the acting MD was raised again in both matters, and the parties made an application to the chairperson. The chairperson has, after the application, directed SITA to provide proof of authority to charge Mr. Pillay and Mr. Mpapuli, and also postpone the matter sine die. Parallel to that process, Mr. Pillay and Mr. Mpapuli referred the unfair labor practice dispute to the CCMA. These proceedings were held in September and again in October, the 9th and the 10th, and again on the 30th of October. And Mpapuli's unfair labor practice matter was finalized and the arbitration award was rendered on the 30th of October. Mr. Pillay's unfair labor practice matter is still pending before the CCMA, and we're waiting the next hearing. In October, 9th of October 2024, we received instructions from SITA to communicate to Mpapuli's representative that SITA had decided to lift the suspension. And on the 21st of October, Mr. Pillay's suspension was also lifted. That's the status of the hearing. Just to conclude, insofar as the internal processes are concerned, the disciplinary processes are still pending for want of a resolution that grants the acting MD the authority to take action against Mr. Mpapuli and Mr. Pillay. And in the external processes, which is the unfair labor practice for unfair suspension, Mr. Mpapuli's matter has been finalized and Mr. Pillay's matter is still pending to be finalized, which we are waiting the date. Thanks, Chair.
Thank you very much to Cliff Decker-Hofmeyr. Minister, I'm not sure if you want to give any other status, any other update in terms of status on the implementation of the recommendations and this report at this point?
Chair, I'm a bit conflicted, just given the nature of how the meeting has evolved, in terms of how you also want to handle whether there should be, because from our side, I think we've ticked the boxes in terms of what was required of us to coordinate and to bring to the committee. But if there is a request on the specifics on recommendations affecting from a department perspective, you can get DDG Shilembe here. And on those that affect the board, I think then the board is here. I'm just mindful of the fact that you said that you're not conducting a hearing and there might be an overlap on those. And then how do we then proceed and draw that line as to whether there's not an overlap into the fear that you conducted, or whether you'd prefer that being done by the board and also us from the department. And that approach will guide us, because, as you said, we don't want to take this to the direction where the committee doesn't want to, because our view was that we wanted all of us to be here when it's being done. And it's a bit uncomfortable for us being privy to the discussion around that. Yeah.
Thank you, Minister. I'll open for the members to reflect on this. I think the issue that is being raised by Honorable Ndlela is the fact that the board, Minister, and please do correct me if I'm wrong, maybe there's assumptions that we made because of perhaps not understanding the dynamics at SITA. We are assuming that the members of the board who introduced themselves in this meeting are the members of the board that you had come to us to say is the reinstated board. So I just want to confirm that as a starting point, because we didn't ask, which board, so we have made that assumption. All right.
Chair, you are absolutely correct.
Okay.
Yeah.
So
Yeah.
that being the situation, then we invited Cliff Decker to present the report, and obviously this would have been a process that was initiated by the minister, effected through SITA as per the request of the portfolio committee. Now, when we said that we don't want to conduct a hearing, Minister, we don't want back and forth whether, you know, the department gets here and present and defends itself in light of the report that's presented. That is not our job. That is not our job. We got a complaint. A letter was written, requested investigation. We're asking for the outcome of the investigation. And of necessity, then, it follows that we then ask the minister, what then did you do given this investigation that was completed? So that's why I wanted to check if the minister has any additions he would want to make insofar as the status of this issue. I don't know if I am clarifying the issue that is raising your discomfort, Minister. Honorable Ndlela, you have your hand up. You want to come in on what I'm saying?
Yes, Chairperson. I was just listening to the minister. The minister says he invited the reinstated board, but there are members here of the board that was then told to step down. That's what I'm saying. There's two different boards here, Minister. In actual fact, if you combine both, it's 3 boards. That's what's happening under your watch, Minister. But I think that's the point I wanted to raise, Chairperson, to say there's members of, like the minister says, that he brought on board, and then there's the previous board members. So that's why I asked the question initially. You know, who's here?
Minister?
Thanks. And it's reasonable that there would be that confusion, Honorable Ndlela, right? The reinstated board then had vacancies. And then there was co-option of members who were in the previous board. So what you're having is a mix of what would be the old board and the reinstated board. Yes, not 3. Your arithmetic is a bit dodgy.
Minister, you're confusing us.
Exactly.
Let me tell you why the minister is confusing us. When you last appeared on the SITA board issue, you said the other board was suspended. Now, the suspended board, can you then take members of the suspended board into the reinstated board? And I suppose maybe we didn't clarify this issue because remember we had asked that it had also been put in writing, which I think we didn't follow up on. But so the other board, is it still, can you just clarify that for us, please?
Chair, there's a distraction from Honorable Ndlela, but to stick to the seriousness of the issue, Chair, when we reinstated the board, right, which meant that on the ruling of that as Supreme Court of Appeal ruling, it meant that that board, which was in function prior to that ruling, would then be suspended as a result of that reinstatement, right? Then we had to do the reinstatement because you wouldn't have, legally have 2 boards at the same time, right? There was then followed by resignations, right, which then left vacancies in terms of the full component of the board. And we then filled the vacancies in order to have the board. And then there are 3 components of that. I mean, 2, there's the other component, which from Treasury, Public Service and Administration to then have their nominees, right? The individual from the Public Service and Administration is the same individual, right? So Public Service, because we need to redo the process, had to notify them, then renominate the person. Treasury, I think, is the only one, and I speak under correction here, that hasn't then filled their nominee from there, because there has to be a nominee from Treasury and Public Service Administration. So the confusion around the personalities, there are some personalities who were in the previous board that would have then been suspended by the ruling of the Supreme Court of Appeal. And that's why we now have both of them here in this reinstated board, because you then have to plug in closing the vacancies that existed by drawing in some of the talent from that previous board. Thank you.
Okay, thank you. Thank you very much, Minister. I think let's move on this issue then. Can we take it that that is then the full tabling of the report as requested, and I can hand over to the members to engage? Okay. Honourable members, the report of the report by Cliff Decker into the allegations of irregularities on the award of a tender has been presented before us. Can I check first if there's any questions for clarity, or if you please, you may go straight into the substantive discussions. Honourable Blose?
No, thanks, Chair. Maybe before we come in, I don't I think maybe I missed it. You had asked a specific question to the minister to say, does he not want to then give additions in terms of, after receiving this report, what did the ministry then do or take up? Or he doesn't want to comment on that, then we can go straight into it.
We've put the question to the minister. The minister then did not have any further additions. Yeah, that was my understanding. Thank you. Honorable members, I'll take hands. Okay, Honorable Matafa, you can go first.
Thank you, Chair. Once again, greetings. Chair, let me thank the presenters for the presentation that was made. It is appreciated and it assists the committee to be able to respond to the complaint that it had received. But Chair, I want to start with a point where I was a bit confused, and you did touch on it a bit. And it also speaks to the last presentation that we just received now, which we do not have. Because normally, Chair, in preparations for such meetings, we do receive correspondence from our invitees. And when we come in with those correspondence deemed to have been read. And then when we engage, we would have made notes in relation to those particular points that would have picked up. I'm not saying it is difficult to follow because these presentations are short, but I'm raising this, Chair, because in my inbox, with the last presentation, I will have 4 correspondences in preparation for this meeting. Now, as I engage, I'm engaging only on the 2 presentations received, but in my medium to long-term memory, I know that I would have come across a 27-page presentation on the same matter. I would have come across the full forensic report on the same matter. So I'm not sure how I'll deal with that confusion happening in my mind, but I thought maybe I should just share. But I think the 27-page presentation might be either the department or the board which will respond, because the information that is in the other report comes across as if it's a rebuttal to the forensic report, one, but secondly, it's showing weakness and shallowness in the recommendations that the Cliff Decker report states. And it also substantiates its position on case law. Matters that appeared before the courts were ventilated. There's case precedents on those recommendations. So I will confine myself to speak to the report more, because the more substantial issues in my mind are in conflict based on the information that I have there and the information that is presented here. And as you say, Chair, we are not opening a hearing, so I will speak to the report as presented. The first question, Chair, is that there is an issue about the report that was presented to SITA being a draft and not final. So direct question, the report that was presented to SITA then, was it final or was it a draft? And if it was not final, are there plans to finalize it? The second question is, if say you respond and say it was a draft, in the presentation, it comes across as if the newly appointed board, now incorporated, had then started engaging on the implementation of the recommendations. Would they have been prudent and legal for a draft report's recommendation to be implemented? So that will be the second question, Chair. I'm going to request a comment on 2 issues quickly. One is if whether what you have found as irregularities are substantive grounds enough to render the entire tender irregular and to be reviewed and be set aside based on your investigation. Again, Chair, I have the rebuttal report noise in my mind. So I'm asking this question not as a curveball, but as what I would have connected with what I would have received. And connected to that, in the view of the presenters or the CDH, are the charges against 2 officials justified and reasonable? I'm just asking because it could have been an administrative error. And in the space where I come from, the majority rules, I know there are laws that govern how boards behave. And you did speak to that, the ratification of a decision that was not fully operational and so forth. But that having been taken into account, are the recommendations, especially on the last part, justified, the last part of the presentation? Linked to that, Chair, which is my fourth point, I'm just requesting that maybe there should be a confirmation if the disciplinary inquiries of the two executives have already started, charge sheets served, and evidence presented. The simple question is, how far is the disciplinary process now, given what the minister had presented in terms of incorporation? Because I'm sitting here, Comrade Subati, thinking to myself, you get fired, I must charge you that you're incorporated. I'm sitting here with you, and the charge sheet, your charge sheet is here before me. So I'm trying to find out what is that process? Where is that process now? Where we are? So you can you please help us with that particular issue? And the labor lawyers that have been appointed to deal with the matter, are they working on the previous resolutions or recommendations of the board? Because for the report to be implemented, I'm sure there would have been a board that said, accepted the report, adopted it, and actioned it. So are they working on that particular mandate? And was the mandate clear? The incorporation of the two boards, does it blur that mandate in any way? And if it does, maybe it's not for you to respond. It might be the department or the board or the minister, but I'm interested to find out if whether are there any gray areas because of their reincorporation. The last point, Chair, if the disciplinary processes were to proceed, what resolutions are required by the new incorporated SITA board? And what is the likelihood that those particular resolutions will be arrived at, given this new marriage that is there? I'll pause there, Chair. Thank you very much for participating. But again, thank you for the presentation.
Thank you very much. Thank you, Honourable Matafa, for that input. Can I check if there's any other members who would like to speak? But I do want to clarify something on the issue of what Honourable Matafa calls the rebuttal report. I've just been handed by the committee secretariat the letter that we sent inviting the department on this matter. We did not make a request for a presentation from SITA. I don't want an impression to be created that we asked for a report. Hence, then, even when the meeting started, we asked for the Cliff Decker report, which is what we discussed. And that's why that so-called rebuttal report, your words, is not on our agenda. Do we have any other hands, Honourable Blosse?
No, thanks, Chair. Greetings to the Minister, Deputy Minister. He has stepped out. And yeah, thanks to the leaders of the presentation as well. I mean, look, Chair, for me, it's very concerning. And I mean, it's just unfortunate that we're not here when the introductions were being done. And, you know, the minister now, when he speaks, he says they drew inspiration or they drew talent from the previous board to incorporate in the new board. But this report says otherwise, that there can't have been talent in that board that was dissolved, if you can put it that way. And we call these things irregular, just to, you know, make them to sound nice, but this is corruption. It's plain corruption. These are fraudsters that presided over these things. It's fraud. Because if you look, and maybe I'm interested to know, you know, part of the reports that you don't name these companies. So you say to us there were 11 companies that originally bidded, one pulled out. and then there were 10 that proceeded. At irregular 2, when the evaluators decided to extract information, obviously there's a company that they were driving all the way to the end. And now I'm interested to know that out of the 3 companies that actually complied with the 90% content, was this company that actually ended up being awarded part of those 3 companies? Because clearly you can see that there was, you know, a direct attempt to make sure that there's a particular company that gets this tender. Also, I'm not sure, man, are we saying that the Western Cape government did not know anything about this? Because you say to us that they got an opinion from SITA or a recommendation 2 days before the round robin was completed, or it was done, and then they proceeded with that decision based on the recommendation of SITA. So are we saying that, well, they acted honestly with the recommendation without actually knowing that there was any irregularities in terms of those recommendations? And again, Chair, I mean, the report, the way it's so damning that it says that SITA sets up regulations for itself and then it does not comply with its own regulations. I mean, what type of a thing is that? You set regulations for yourself and then you can't comply with your own regulations. We have been taken for a ride here. And that's why, Minister, I'm saying I don't agree that any of these previous board members should be serving, because they are going to come now and try and do something here to protect their fellow people or even themselves. Because we need to take this forward. And I'm really disturbed also, Minister, with yourself, that you got this report, you're sitting with it, and you don't even want to give us or take us into confidence in terms of how you are taking this forward, or what is even the view of the ministry. So the ministry has no comment on this thing, nothing. You don't want to tell us anything about it. That for me is very concerning. And maybe as a last part, Chair, I also don't understand the you have to take me into confidence on this one. With the irregular one, when you say that as part of evaluation, so that's why I'm saying take me into confidence. You're saying so the pricing option, the 2 pricing option, was not noticed in the first 3 or 4 evaluations. It was only picked up at pricing. So when bidders submit bids, do they not incorporate the pricing, or then you say that if an entire tender is submitted, then maybe the evaluators have only got the scope to say they evaluate a certain portion and then they stop there. They don't look at anything else, and then other documents are, because also I don't get why this pricing option was only picked up at that end, and then also even after it was picked up, it went through, because there was an legal opinion given to this thing as well. So people went and seeked a legal opinion, and then they got an illegal legal opinion about those things. So those things are very concerning for me, Chair. And I don't know what the attitude of the committee is going to be as well. I'm very interested in that, Chair, to say that maybe after this process, we might then need to look at this thing and see how then do we take it forward. Thank you very much.
Thank you, Honourable Blose. I'm aware of time, Honourable Members. The DM had requested to be excused at 12. DM, I want to check, would there be any input that you would want to make before you're excused?
Thank you, Chair, for that considered question. I think the little I can say, Chair, is that now, because of the nature of the report on the table, at times I'll pretend I was a minister. Now I'm a deputy. What I want to say is that when this investigation was requested by Parliament, as it is reported, we sent it to SITA to actually take it up, which led up to the process that Cliff Tagger now is reporting. My recollection on record is that the board, which is said to be suspended now, that board took the report and implemented it. Maybe what would be critical is the progress. I'm sure somebody asked what's the stage of implementation. And we handed over the report to the oncoming minister in that regard. That's the little I can say about it.
Thank you very much, DM. I'm not seeing a hand. Maybe can I give the colleagues from Cliff Decker an opportunity, because they got quite a number of questions before them, and then we'll come back for a second round. Yes, do you want to proceed, madam?
Thank you, Chair. I'll address the first question in terms of the status of the report, draft versus final. We went through a process of finalizing the report. The report that we sent to SITA was marked draft because we made provision for anything that would come back after consideration by the board. The board went through its process, and this is from our understanding, the board went through its process of reviewing the report. Communication was then sent to us that the report had been accepted as final. That report then proceeded to the channels that the department or the SITA board then took it through. But for all intents and purposes, that document that we had been submitted was communicated to us as final. That is the report that is final. That is the report that, from our understanding, has been sent through to other parties. So it is one version, and it is the final version of the report. The second question was on the irregularities and the question of the substantiveness of our findings. And I think there was a question around case law, and I think reference. I won't touch on any other presentations because we refer to this. In terms of the procedures that we undertook, we took factual, forensic, and legal procedures in considering this matter. And this really is based on the skills that we hold. So we sit in a law firm, but we sit as lawyers, as accountants with additional forensic experience. So in considering these issues, we went through a very rigorous process of analyzing them through those three specific lenses. So when we found these 4 irregularities, these are what we considered material irregularities. These are irregularities that had a direct and substantive impact on the result that came through the procurement process. So I think in response, and I'm not sure if I've responded correctly, we considered these irregularities not to be frivolous in any way, but substantive irregularities that had a direct impact on the fairness, the transparency, and the competitiveness of this bidding process. I will then hand over to Yvonne, who will speak to the disciplinary questions.
Thanks, Tendai. Thanks, Chair. The first question is around whether or not the charges are justifiable. I think the context of internal processes and disciplinary process is in essence about holding people accountable. At no point does the attorneys make decisions, and that is why the process that is undertaken is independent. But the charges they flow directly from the report. For the executives to state their side of the story, and for an independent chairperson to come up with the ruling. And I think just flowing to the next question, the confirmation of where is the process itself. The presentation itself is meant to give that feedback, and in essence, honourable member, is that the charge sheets were served on the 2 executives in February, and secondly, the disciplinary process were undertaken and the first sittings were held. As we speak today, as I said in the presentation, that the chairperson has ruled that the acting MD did not have the requisite authority to charge and has requested or has directed that that must be regularized. And that means there has to be a resolution from the board that regularizes that authority. Because in terms of the delegation of authority, it is the board that can act against the company secretary, and the executive can be ordinarily the executive can be also be charged by the MD. I think the question around whether or not the current board can issue the resolution, when resolutions are being passed, the sitting board, you don't set aside those resolutions because there's been a change. They remain valid. So to the extent that there is a need, we are required to issue another resolution, the sitting board is able to issue that resolution. Thank you, Chair.
Thank you very much.
We still have...
You still have, okay.
Questions to respond to. Thank you, Chair. The next question pertains to irregularity number 2, which is local content. And the question was around the process that was undertaken and whether the company that was eventually successful, which is BNC, was one of the 3 that had answered correctly. BNC was not one of the ones that had answered correctly. I think if we can just pull up the names of the 3 that answered correctly. So BNC did 2 things. Firstly, they submitted 2 forms that spoke to local content because of the issue of them having the 2 pricing options. So that was an irregularity within that local content issue. And then in terms of the answers that they provided, the calculations were actually incorrect. So they did not provide the correct calculations. The companies that answered correctly were Nexio, Dimension Data, and Business Connection. So those were the 3 companies that answered correctly. The next question pertained to whether the Western Cape Education Department knew of the process and the decisions. Yes, the Western Cape Education Department, and in some instances government, Western Cape government officials, not necessarily from the Education Department, were part of the full adjudication process. So what would happen is they would be the decision makers on the committees. So where you had your evaluation committee, they would sit on every committee. They were party to the discussions that happened there and then the voting thereof. So when it came to coming to the conclusion of this matter, they had been part of all of the discussions, they had been part of all of the decisions that were made through that process.
Order members?
And then I will move on to the last question, which pertains to irregularity number 1. And Hilary, if you can just go into that one, please.
Thank you, Chair. I'm just going to go through the process of the evaluation. So the evaluation of this tender was in 5 stages. The first stage, which was the administrative and pre-qualification verification, and it is important to note that these stages were all separate, and there were committees that were separate that would conduct each and every evaluation at each stage. The second stage, which is stage 2A, was the technical mandatory requirement elements evaluation. The third stage was stage 2B, the technical functionality evaluation. The third stage was the special conditions of contract verification. And the last stage was the pricing and BEE evaluation. So all these were separate evaluation stages that would happen at different times. So as we had indicated during our first presentation, that it only came to the attention of the pricing evaluation committee that there were 2 pricing options. What it means is that the technical mandatory evaluation, they were not aware of what was represented at pricing and BE evaluation stage. So at that stage, they just looked at technical mandatory requirements. At that stage, they just looked at technical functionality requirements. It was only at a later stage, and it is also very important to note that the price evaluation is the last stage of all the evaluation stages. So the evaluation had gone through all the other phases, and then when it came to the price evaluation, that's when it was noticed that a particular bidder, BNC, had responded with 2 pricing options. Thank you, Chair.
Okay, maybe let me just ask some questions before I give to the members. The burden of chairing is you don't really get to engage. But I want to understand really, on the issue of these employees who were suspended and now back at work, Minister, through you to the CEO of SITA, did the CEO have a mandate, acting MD, have a mandate from the board to initiate charges against these 2 individuals? That's my first question. There's a jurisdiction issue that is raised around the acting company secretary, but I would have assumed that if a board had given a mandate for that, that would have been done. Similarly, that argument then does not apply to the second individual who is not the company secretary. So why then has that person's hearings? And what is the basis of those individuals being back at work? I think I'm not understanding. There's a board. Why would the board not have given a mandate if it was faulty in any way? Then this report that we're talking about, has this report been reviewed in any way? Because listening to CDH, they're saying that the report is final, the report is there. Now, if there's going to be any questions around it, have you reviewed this report? Or have you reviewed even the contract itself? What's happening with the contract as we sit now? Because the recommendations speak to the fact that you may want to seek a review of the contract. And then I'm interested to find out, if Western Cape officials were making decisions, why are there no findings against Western Cape officials? I'm asking this because you suspended company secretary, you suspended chief procurement, but I think when Madame Tendai was presenting, she kept saying it's important to note that the Western Cape officials were the one who were making decisions. SITA was mere coordinators. Maybe that question is not for you, Acting MD. The lawyers can help us, because none of the recommendations speak to the people who went to extract, in your words, and read into submissions. They don't speak to the people who said, you know, yes, 2 alternatives, this and the other issue that has been raised. So I just want to understand, because for me, those are fuzzy issues, but the status of the contract. Honorable members, Honorable Potlani, I note you, Honorable Ndlela, and then Honorable Matafal, and then finally will be Honorable Subrathi.
Chairperson. Chair, I think for me, maybe the first question is, why does it look like this report was shrouded in secrecy? And I'm not even sure whether this is a question to CDH or to the department, but it looks like it took too much doing for this report to surface. What was the main reason for it to be shrouded in secrecy? Well, that's my perception. And Chair, you were at pains to explain to the Portfolio Committee that this is not a hearing. What outcome are we looking for as a Portfolio Committee? Are we receiving this report merely as information and engaging? And this is a direct question to yourself, Chair, and perhaps it will also guide guide ourselves further as we engage with this. And Chairperson, at the beginning of the meeting, we did receive the introductions, and there's a great appreciation that there are members of the board that had been suspended, and they were reinstated because of the board decision, the court decision of the SCA. And I'm tempted to say, and then there's the Kungubele board, but let me not go there. And then there's and I don't even know how to structure it. But for the sake of explaining myself, then there's the second board, and then there's the third board, which is now incorporating also part of the people that were reinstated at the SCA, and some of the people that were taken from the second board to form the board as we have it now. That, Chairperson, leads me to the point that This simply means that the question that Honorable Matafa was asking about the draft or not draft can be answered by the people in this room. And this is exactly the point you were making, to say people are here to exactly speak on that. Noting that they are in the room, can we perhaps allow somebody, I'm not sure who, would be able to speak to this, to say, how do they view this? I think it would help us greatly. And because now what we are seeing is the report, which is greatly appreciated, and the presentations were really clear. And I do also appreciate that it wasn't brought in as a high-level report, but it was a report that we could also appreciate and understand. So that is my question. How far are we going to engage the board? Chair, the Western Cape issue, with all due respect, I felt there was a contradiction with your presentation. When the presentation was first made, I was left with the understanding that the Western Cape approached SITA to say that they wanted a service. And SITA, as an intermediary, becomes part of the process to assist the Western Cape, because now SITA is the expert on this. But in your presentation, there was a contradiction in terms of what the participation of the Western Cape was. And that with your first presentation, I was comfortable to say, no, then we do not need the Western Cape to speak on this. But with what has just been said, I would love to also hear the voice of the Western Cape to say, if the Western Cape government was the initiators of the contract, and they had representatives in the adjudication committee, but still the same Western Cape had to receive information from SITA, which we are now being told the word that inoperative information. There is a disjuncture in my mind to say, how are you part of the process throughout? And when you are part of the process, by the time the decision is made, with the complexities that you have also alluded to in terms of how the round robin worked, it was maladministration. But how do you then have how do we place the Western Cape at this point on the issue to say just clarity on what their participation is, and then Chair, that will also guide if we should then give them an opportunity to speak, because clearly this centers around them. And back to your question, what were the findings on the Western Cape people who were part of the adjudication? And if I read the 174 pages, I did not pick up anything in terms of themselves and also having interest in this as opposed to the other members. I was shocked to see that there's people who could have directorships in 24 companies, and we thought we all had 24 hours in the day. Clearly we do not. But the question for me, the biggest question I think of the day, all the processes that have unfolded so far, was it malicious or was it maladministration? And if it is maladministration, how do we come back to South Africans and tell them that these two people who were appointed in this report are back at their jobs with zero consequences, and with the greatest appreciation that there has been processes as far as the SCCMA and the suspensions and but the end of the matter is that they're back at their jobs. And the questions that an ordinary South Africans would be asking is that, as we tussle with this whole thing, where does this leave the children of the Western Cape? Because this was supposed to be something that has been done to empower the schools of the Western Cape. So where are the children in this scenario? How is this tender process going to disenfranchise children that are supposed to be assisted by, and we're talking about bridging the digital divide. So that's my question. And with the forensic investigation that you would have done, I am interested in also understanding, is this sort of processing of a tender an isolated process? Or is this just how the supply chain management of SITA is inefficient? Because this was clearly not the first time that the tender process was being carried out on behalf of a government. So at which point does SITA blunder a process this much and it becomes business as usual. It cannot be, because at the end of the day, this was a massive project. 1 billion of taxpayers' funds is a lot of money for us to be sitting here and really dealing with it as a by-the-way process. What was the consequence management? And was it prudent for SITA to then have this big contract being given to one service provider? And my biggest worry, Chairperson, is that had the aggrieved service provider not come up to say, I'm aggrieved because of these processes, then this would not have surfaced. It means that there could be other tenders that are disadvantaging South Africans who should be benefiting from the work of SITA that are sitting there and they have not been touched because there has not been anybody who's coming up across to say, I'm aggrieved. With the investigations that you have done so far, would you believe that there could be some of those? And that's something that obviously the portfolio committee would need to look into. I think Babu Plose has spoken at length on the issue of the two pricing options and the two bidders correct and small margin and what was said. And again, the point I want to make is what your findings on irregularity 3, for example. And back to the question of, was this malicious? Because I'm tempted to believe that a company like Dimension Data, for example, would not have been the first time that they are bidding with SITA, for SITA not to know that they've got this and that qualification, for them to be disqualified on something like that when it is their core business. That then says, what was the interest in making sure that this goes the one way and not the other? And the company secretary, we must get into a culture of South Africans of declaring people delinquent directors and blacklisting people who are going to be delinquent directors. Because your own presentation says the person who should be held accountable amongst others is the company secretary. So perhaps this is a question to the department. What consequences has there been or will there be? And what powers do they have? And with an appreciation that there's a CCMA, my feeling sitting here, Chairperson, is that people are going to walk scot-free while children who are supposed to be the beneficiaries of this project are sitting and not being able. And we will talk about digital integration, digital development as a pipe dream unless we answer these questions correctly in this meeting.
Thank you, Honorable Bonjani. In your questions, you answered the question you had to me in terms of what outcome are we looking for. We have this item on the agenda, Honorable Minister, because we were informed that an irregularity had taken place. We wanted to know the nature of it. Honorable Bonjani asked a correct question. Was it maladministration? Was it malicious? What have you found out in that regard? And then what has happened? Who is being held accountable for what has happened, both at an institutional level and an individual level, and as it relates to the contract? Honorable Ndlela?
Thank you, Chairperson. Now, for me, where I'm at when I assess the sequence of events and what's happening here, a number of things come to me, and I just hope that's not the case. But let me share with you what I'm reflecting on. So the Western Cape provincial government participates in a tender process. A company gets awarded. This award is flagged. In comes a minister from the DA, removes that board that was appointed after, reinstates the board that appointed this company, and then here we are, protecting, it seems, in a form of even reinstating some of those same board members back to seemingly protect this award to some extent. That's how it's looking to me. You know, it's just got DA, and I'm talking now from what I'm observing, written all over it, because the provincial government of the Western Cape is the DA, and so is the Minister of Communications. But having highlighted that, which is of concern to me, because sometimes there's more than meets the eye in certain things we know in this space. Now, when the report refers to the board being held accountable, and I think this is where the minister didn't understand the issue of governance, and he refers to arithmetic, supply governance, demand governance, Minister, King 3. I'm referring to, if you're going to be holding the board accountable, are we referring to the 4 members, I think, that have been reinstated, or the 5, or the whole board being held accountable? Because we're referring to an oversight issue here, and we want to hold the board accountable. The report refers to the board. Are we saying the whole board, or just the 4? Okay. The other primary issue is there was a reference to a legal opinion that was taken by the previous board leading up to the award. It would be interesting to see what that legal opinion said and how it guided them regarding the procurement process that ensued at the time. Because you see, we have Cliff Decker, in this case, giving us the overall findings. But I think there's a critical element here that would have given some sort of guidance to the board and the executives in terms of what is the situation and what's the lay of the land, I guess, from a procurement process and a legal framework perspective. So we haven't had sight of that. It would be good to actually have sight of that too, because I think there's a lot that will then help us in terms of holding people accountable. Yeah? Because it would have been clear in there pertaining to what needs to happen. And then, Chairperson, the Cliff Deckhoff Mayor here refers to material irregularities. These are serious issues which are substantive based on their report. And now we have board members that have been brought back. And by the way, I have nothing against any of the board members. It mustn't seem as if I do. So if they are here, they must just know I have nothing against them. I'm just looking at it from a pure governance perspective and accountability. That issue of the material irregularities, I want to know what then informed, if those employees are back, for instance, including the minister's position in terms of reinstating them, knowing that there are these material irregularities, which are very substantive. What was the thought process in taking that decision? And also as it pertains to the same employees that are implicated in this procurement process, of which again have been found to have made decisions and been involved in a process that is totally irregular, them being brought back into the organization and to preside over their duties, which have been questionable or questioned. So I want to know what is that and what's going to happen and how that's going to unfold. And the contract itself, by virtue of the findings which are materially irregular, is the contract going to continue? And I think, should we not be having a discussion about why don't we just stop this tender and stop this work? Because a continuation of this contract will only perpetuate what is in the findings. And in actual fact, it's going to open us up to even possible legal institute, and the other companies could institute legal proceedings against us or the institution itself. To say you knew about this report, yet you let this contract continue, and you said yourselves that these findings were irregular and they are substantive. So it opens us up to, or the organization SITA, up to potential court cases or potential court bids. So thanks.
Thank you, Honorable Ndlela. I think next is Honorable Matafa, and welcome Honorable Chauke Adonis. I saw her somewhere. Dear Honorable Mataf, I think it's Honorable Mkhaga. You had the first round. Yes, you did. I think it's Honorable Mkhaga. And I'm not saying this because it's you, Honorable Mkhaga, but please look at the time. I'm not picking on you. It's almost 12:30. Please proceed.
No. Thanks, Chairperson. Good afternoon, all members. And Chair, it's a very complex environment, and I'm sure post this particular session, we would need to have our own session as a portfolio committee, so that we're able to tease some of the dynamics that are emerging in the meeting. Because Chair, now is directed to the MD or acting MD as a top manager. To elaborate more on this question of, or the purpose of lifting this suspension. I'm interested because somewhere there's talk of involvement of the CCMA later on, in fact, which of course is the supreme body to manage labor processes and procedures in dealing with matters of this nature. I think I just need more elaboration on this one. The second one would be to tell us as to why this review application to be set aside, this illegal tender has been delayed. Because the time factor becomes an issue here, given the prescripts of the law. The other issue is to exactly what is required, and I'm asking this question under the assumption that the first board commissioned investigation. The first board commissioned the investigation. And I'm not aware exactly, didn't capture very well as to exactly which board started to implement the recommendations. And given this quick change of boards, I don't want to get into dynamics of this third constituted board, just focusing to the first board and the second board. Given those dynamics, what was required for you as a manager to proceed with the implementation of these recommendations? The last one, Chair, just to take us into confidence in relation to suspensions or withdrawal of disciplinary processes or inquiries, whether this practice is a common occurrence within SITA or not. And I'm elaborating on the basis of the other member next to me highlighting that very same question. Because we're only dealing with one matter here that involves 1.2 billion. And SITA, we know, is a custodian in government of managing these content issues as far as this. Can you take us into confidence? So that if it's an exceptional matter, we understand, but if there's a common practice within SITA to deal in this fashion with these matters, we are aware of this. We're seeking that clarity because we don't want to confuse ourselves when we're meeting in our own meeting. That's why it's very important to deal with this matter. This question of contestation over authority it's a matter, and I don't have words to express it, but it raises a concern for me that a decision was taken by an improper body. It was challenged on the basis of your authority or delegation of authority. And then that was, whether it was corrected, but who then advised, because here there were legal fundis, and I doubt, and I'm confident that the institution has got legal fundis, who advised those boards to take decisions that are in violation with the law. Because SITA is a national body. It can't take things for granted. Whatever decision it takes, it has to assure compliance and conformity with the law. But in this instance, a decision was taken in relation to who is given this delegated authority to take this decision or not. And I'm not asking the merit and demerit of the case. The question is, as an MD, what has been your role in terms of ensuring that proper decisions are taken at all material time? Thanks, Chair.
Thank you, Honorable Mkhaga. Honorable Subrati, then Honorable Vilagazi. I think that's the last hand. Then maybe we'll entertain Honorable Maltaf. Maybe. Honorable Subrati.
Chairperson, may I please ask, perhaps you to ask Honorable Vilakazi to go first, because I see the Minister has just stepped out and my questions are more focused to the Minister.
Honorable Vilagazi.
Thank you, Chair, and greetings to the House. I will start maybe just by addressing what I feel is a misconception by the Honorable, the learned Mr. Ndlela, and just state the fact that the suspension, I think we will all know, the suspension of the board members happened before the Honorable Minister Malatsi's time in government. I believe they were suspended for a matter pertaining to the appointment of I think it was the executive, it was the MD at the time. And this board, 3 members of the board were then released by the ANC minister, not a DA minister. In fact, the court then, in this dispensation, the court then ordered that those board members be reinstated, and it is to the credit of the DA minister that he has been able to manage the dynamic in a manner that there is actually a functional board even as we speak. So I just thought I'd address that first and make sure that we clear that misconception.
You are talking about GNU ministers, you are dividing us. Thank you.
We've been divided already. You did not give us this cover. Chair, you did not give us this cover when the division first started. And then... It was the Western Cape appointed. And then, Chair, many of my points have really been raised, but and so I won't go back over them. But for some of them, perhaps just a different perspective. But I did feel to just follow on what my colleague has said. Initially, in your report, you said in the communication to the Western Cape between the round robin and the ratification of the decision, the communication was premature. And it happened without any involvement of the Western Cape, or any involvement of the Western Cape. And then later on, you came back to say the Western Cape was involved in each and every stage of the process. And so, in my mind, I'm also just unclear. And can you please just clarify the culpability of the Western Cape in this particular scenario? And then the other one has to do with the point Babu Mkhaga just raised. What is the status of the actual implementation of the tender now? Are BNC continuing to work? What is the process? And then just the other thing is, we've addressed the capability of the Western Cape. The other thing is this report on the human resource consequence management issue. I was a bit confused by the report, and I think, Chair, it's good form for us to receive these reports beforehand so that at least we can just apply ourselves to it and understand what it is we're looking at. I wasn't sure what I was looking at. Is CDH just telling us what's happened? Are those actions, were they being directed by CDH? What is CDH's role in what you told us? Also, you said, ma'am, that those actions took place as a result of CDH's initial report. Now, if these staff members have been reinstated, was the CDH report wrong initially to have led to the suspension of these members, or was it merely applied wrongly by the board or by the executive within SITA? I just had those that confusion in my mind. And is there a chance then that they will be charged again? Could they be charged again, or are they now scot-free? Coming back to Honorable Bodlani's point, are we now proceeding without any consequences for anybody with what, according to CDH, is a material breach of processes, rendering the process null and void? Thank you, Chair.
Thank you, Honorable Vlegazo. Honorable Subrathi.
Thank you, Chair. Chair, let me welcome the contributions of my colleagues who have covered me largely. Chair, let me begin. I'm mindful of time, but at the same time, I don't want to not say express what is within me, since I'm probably going to be the last member from the committee who's speaking at this stage. Chairperson, let me appreciate, I want to focus a little bit on the conversation around the responsibility of the Minister and the DCDT. I just want to go back to how this matter emanated. It came to us via a letter in the 6th administration alerting us to the existence. And the then Minister, upon receiving that, then the Portfolio Committee then requested the Minister to respond. And then the Minister responded by asking SITA, and then a commission went into it, an investigation went into it. So I can see the level, that is the level of leadership I would expect when I started off. And then there was a handover in the new ministry and new leadership that came in. And Chairperson, I understand there's lots of process, and I don't want to get into the details of the report. I think there's a lot of lessons learned in tendering, but I want to focus a lot about as South Africans. We saw that there was a handover, there's a problem investigated, there was a report that came up. So my question, to the Minister, and I'm asking this humbling, and former Minister, the DM, as he exited, mentioned that there was a conversation about a handover would have taken place. So this entire issue surrounding the existence of this irregularity, the Honourable Minister has been aware of it. So the question is, what is the Minister's response to this knowledge, having had this? So I'm presuming that DCDT and the Deputy Minister confirmed that this appraisal took place. And this would have happened around about 3 months, 4 months ago, around about July. Now we are sitting 4 months later. In that period, the members who were suspended of the board have been appointed back, and that was a decision of the court. But what concerns me is 2 members who were implicated directly in this report have been reinstated. That entire disciplinary proceedings probably ended. And they'll probably be asking, okay, if you ended my disciplinary proceeding, I incurred legal costs, and they'll probably want to claim from SITA, pay my legal costs. And they had an opportunity to clear themselves. A disciplinary proceeding is a great asset of this democratic dispensation. It allows an employee to come forward and clear his name. And that process was pulled. And I'm sure the Honourable Minister and the department are aware of this process. I mean, has the Minister, does he have his finger on the pulse in terms of this? Because this has very significant implications. So I would really like to know from the Honourable Minister is
has he been fully appraised? And what is his actions been for the last few months in this matter? And particularly now, if you look at what's going on, considering that before us is an independent forensic report, and I don't want to go into the rebuttal report, etc., because there is a very conflicted environment we are in. But we need to confront this conflicted environment and gain clarity, because that's what's demanded of us. As we sit here at the moment, based on this, there is an irregular contract that's continuing in the Western Cape, and our children need this service. But 4 months have gone since this report has been handed over. What is happening to address the existence of that irregular contracts that is in place by the department, by the minister, to say, okay, fine, whilst we're addressing this, let's concurrently start a process, etc., to address it, because we cannot sit here and say, we have a 1.2 billion rand illegal contract in place, and we're doing nothing about it. Chairperson, I'll stop there. I would really like to hear the leadership and the stewardship of the minister. How is he managing it, and how is he taking this process forward? Thank you, Chairperson.
Thank you, Honorable Suprathi. Honorable Matafa, if you will finish in 1 minute, I'll give you an opportunity.
Yes, Chair, I will. In 30 seconds, I'll be direct to the point. First question, court order to reinstate the previously disadvantaged board. Are there any directives to the minister to dismissed previously dismissed board? Are there any directives to the minister in terms of how you process such matters that you need to implement? If yes, how far are you in that regard? Similar to that question to Cliff Decker, in your investigation, did you identify any legal gaps in the SITA Act or in their policies of procurement that you need to recommend on to ensure that this does not reoccur? Cost implication from investigation up until the finalization of the disciplinary charges. I'm interested just to hear if whether we have a number. And Chair, I'm tempted to go into the merits of the investigation, and I've been trying to restrain myself. Okay, thank you, Chair. I'll be guided by you. Thank you, Chair.
Thank you, Honorable Matafa. I'm asking you to Bonage.
No, it's 10 seconds, Chair. I wanted to come in when I came, when my response was given, because I extracted the information of the involvement of the Western Cape government. So you can clearly see now that the most governed or well-governed province of the Western Cape is actually corrupt, because this thing of corruption is always put in color. And the one thing I want to say, Chair, is that it is clear now why in the GNU they negotiated for communications, because it seems as if the minister is here now also to play a part and protect this thing. That's why he doesn't have an opinion on this thing. So we ought to move as a committee to actually cancel this conference. I think that's what the position of the committee should be going forward. Thank you very much.
Thank you, Honorable Blosse. Can somebody please write to Honorable Matheus? We miss her. Seriously, thank you very much, honorable members. Minister, we're going to hand over to you to lead the responses. I think you can tell that the committee is trying to grapple with this issue and come to the not the root cause, but to come to the crux of the issue, because you will get the sense that there's a sense of frustration that we are at this point so long after we would have raised the issue, and it seems like we have even moved back rather than moving forward in terms of people being held accountable. I am aware that Honorable Gungubele had written to the Honorable MEC of the Western Cape at one point, Honorable David Maina. And I'm not sure if you, Minister, coming in, have also had any conversations with the Western Cape, specifically as it relates to where to from here, now that we are here, you know what I mean? So we will, as Honorable Honorable Mkhaga had said, probably need to reconvene again and deliberate on this matter, but if you could please just guide us in terms of the issues. Thank you, Minister.
Thanks, Chairperson, and thanks for that. So let's just start with the sequencing of events, because I think there are two things that are being mixed up to imply that for some reason there is a political conspiracy to make sure that there's some protection of other people and to facilitate the Western Cape getting this. And I think it's important to clear that, because the reinstatement of the board was a legal process. It was a legal obligation, and it stems from a separate case that has nothing to do with this report. It stems to the process about the appointment of a managing director who has since left the role, right? So as a result of that appointment, there was a process that was initiated by the current DM in his previous capacity against the board that combines of some of the individuals that we are here, including the current chair, that initiated a process of dismissal, of the board. I think on the 18th of, what's the date? In 2023, 18th July 2023. The board then contested that dismissal. Won their first case, won their second case, ultimately leading to the SCA saying they must be reinstated, right? During that period, as logic would dictate, another board was appointed, right? Rightfully so, because, there wasn't a board at the time. That board was appointed. It was chaired by Mr. Pillay. Mr. Alvuyo Geisa is also part of the individuals that were in the board, right? So as that legal process unfolds, there is also the transition that happened, right? That transition culminates in that Supreme Court of Appeal ruling to say that you must reinstate. It's not a choice. It's not something that was up to my emotions or feelings, right? We reinstate that board, right? But prior to that, we would say that because of the ruling, right, it would mean that the board that was in charge at the time is suspended while we apply our mind to the various elements of implementing that judgment and what it would mean, so that the reinstated board assumes its role as is dictated by law. A step further to that is that we then formalize their reinstatement, which means that the board as led by Mr. Pillay cannot function, because you can't have 2 or 3 boards as you rightfully implied. Sorry? It's a legal process. It's a, and I didn't interrupt you.
Honorable Ndlela.
Yeah.
Minister,
No.
you may address, may or the meeting leave.
Yeah, but I'm
Honorable
just saying,
Ndlela. Thank you.
Chair, I didn't interrupt me, and I enjoy conversations with him, by the way. But I didn't interrupt.
Guys, do you want to
him,
get a room outside?
Right. So the motive and the reasons aside, the legal process, court ruling outlines that they must be appointed, right? So that means that you can't have 2 boards at the same time. They step aside, some resign, and we realize, and this is a choice that we face, right? You now have a reinstated board that doesn't have the full component to have a full component of a board that can correct, right? And in my consideration, say, okay, we've had people that were in charge during that time. Therefore, find a mechanism to ensure that there is continuity, so that there has to, and this meeting actually proves the point that, the effort we took was justifiable in pulling in the former chair and some of the individuals, so that if there are questions that would emerge about events that happened during that period that this reinstated board was not there, that the individuals will be there. And some of them are here in the room, right? So that is where we are in terms of the composition of the board. So it's not a congregation of 3 different boards, but we filled vacancies with people who had spent time on the board so that we have a full complement. What is clear now, Chair, to come to this matter is that at the time the report was presented to, and I'd use this to so that we simplify it, to the board as chaired by Mr. Pillay. They interacted with the board the way that they did, right? And it's now clear from the reporting that there was movement on some of the recommendations that the report had made the case. The reinstated board then comes in, right? It looks at the report, and and this is why I think it's also key that we get to a stage where they can also reflect on the board. But they then had their own assessment of the report. And I think the presentation that Honorable Mataba was getting into highlights their views on that report, right? That's where we are in terms of where the board is. right? And secondly, you asked a very key question: has this report been reviewed or not? There is no, it hasn't been reviewed by a legal process either to set it aside or not. So I would want to get into the prescripts of saying, you know, it is on the minister's duty to cancel the tender or otherwise, because that is an administrative process. That isn't us, right? Secondly, the point being made about what actions have, you know, we taken from us. I think there has to be an appreciation that during the consideration to reinstate the board, we then had to make sure that we try and get a balanced composition, right? That balanced composition, for me, the motivating thing was there's a legal process that imposed this outcome, but also, and importantly, in the 6 to 9 months that the board under Mr. Pillay was in charge, there would have been key decisions that were made that it would be useful to the functioning of the board to have those members as part of the board. Because when that reinstatement happened, it didn't reflect on their capacity or otherwise to do their job or not. The same with the reinstated board. There's no pronouncement. Any inference can be made by what the report says in terms of, yes, what the report says needs to happen. And I think it's important to depart from the status of the report. I mean, CDH indicated that when they presented to the old board, their understanding was that it was, you know, a draft report, but that was due to then for the board then to be able to express itself, and on those questions that we'd have, then it would be a final report. And I think, Chair, because the key players in the decision-making process are in here and are still part of the board, then it's key then to establish that, no, that, you know, the board that was in place from the 18th of 23 to the 18th July 2023, up until the reinstated board accepted this as a draft board, and that equally, that is their understanding, and that there hasn't been setting aside of any board resolutions that has happened since to date. On the issue of the Western Cape, any communication with the Western Cape, we haven't had any communication with the Western Cape Department on this too. So, and that is because, one, the legalities around, or the questions that emerge around the legalities of this tender hasn't been finalized. So what position is it for us to then move from the angle of engaging the Western Cape? No, I've never engaged them. I've never engaged them, to answer you. And that is where we are, Chair. And unless there is a clear requirement in terms of, here is a requirement that there was wrongdoing on the part of the ministry not initiating the action with the Western Cape, and that wrongdoing then gets articulated, then will be, I think it will be reasonable to engage it at that level, because even the correspondence to the Western Cape by my predecessor and now the deputy, I haven't seen it, so I've got no knowledge of the details of what that correspondence says. Thanks.
Thank you, Minister. There were a number of questions addressed to the acting MD.
Thank you, Chair. And members, I noted a couple of questions that were raised for my consideration and responses. I'm going to try and respond to all of them. Most of them are related, dealing with the issue of the suspensions and so on. I can say, Member Mkhacha and members, that I started at SITA in February. The two gentlemen that were suspended were already under suspension. And as the report had stated, through various interactions, after charge sheets were sent out, and after the disciplinary hearing processes had commenced, there was an issue at some point about whether I have a full mandate of the board to run with the process. And indeed, the board that was there at the time issued out a resolution mandating me to run with the matter, and we proceeded accordingly. Now, when there were changes at the board level, then there were questions about decisions that were taken by the previous board, led by Mr. Pillay, whether they hold still, and whether I still carry the mandate to run, this disciplinary process. And I remember the request from the chair of the disciplinary hearing was specific, that the AMD must be given a fresh mandate within 7 days. I never received that mandate. So the matter stood at that point. There's been no progress. The charges have not been withdrawn. So they can continue anytime, only if I was to get a mandate or a board or a fresh board resolution. That I have not been given, I can say that. So the matter is in limbo as we stand now. Instead, there was a discussion at a board meeting to the effect that the report is noted, there are issues about it. And the second part was also presented at the board meeting, and after engagements with it, a resolution was taken, Chair and members, that the suspensions must be lifted. Firstly, of that of the company secretary, or the former acting company secretary or legal officer, and subsequently that of the other member, the chief procurement officer or head of the thing, SCM. So based on the instruction or resolution by the board, actually in the letters lifting the suspensions, I'm not arguing anything other than to say based on the resolution of the board, the suspension is lifted accordingly. I didn't deal with the merits of that and so on. There was a context to the discussion about whether the resolution taken by the previous board is then rescinded or not. And there was no specific, comment on that. There was an issue about whether the report from Cliff Decker was being, not accepted by the board or not. And again, there was no question or response to that other than to say we will get a legal opinion, about that. But on the question of suspensions, there was a specific item or resolution that they must be lifted from the board, yes. And that's what I acted upon. There's a... No, I'm saying the board...
Honorable members, we are receiving the responses. And we've agreed that we're going to go and reflect. Okay. Honorable Botlani says she could not hear you. If you could repeat what you just said.
All right, there was a board led by Mr. Pillay that had resolved that I must continue with the disciplinary charges. They provided the chair of the disciplinary hearing with a resolution to that effect, and I continued accordingly. When there were changes at the board level, the two officials raised the issue again through their lawyers, whether I still have the mandate. And the chair of the disciplinary committee said then within 7 days, the board must give me a fresh mandate to continue with the disciplinary hearings. And I'm saying I was not given that resolution. Instead, the resolution that was taken was that I must lift the suspensions. And that's what I did. And that resolution was taken by the board. The current board. Maybe I need to say
the
that was...
Malaxi board, not the Gungubela board.
No, I'm not going to get to that.
Okay, I call order on the chair.
That was before the two boards were integrated. Yes, that was before the two boards were combined again. Yes, so the reinstated board took the decision. So the second point is that the costs to this matter are huge. Huge in the sense that you had two officials who were suspended and they were getting paid throughout. Then you had people acting who were also getting paid. Then you had lawyers getting paid. And then after the suspensions were lifted, one of the officials has already returned to us demanding that his lawyers be paid 1.2 million. And my assumption is that others will come as well, because that's been the pattern. When one does something, others all follow the same suit. Like the board. I'm not going to get to that, so I don't remember. So there are huge costs, probably they are standing now about 5 million, just on these things. Or maybe the last part to that, if then we we terminate and we don't proceed, technically the Auditor General will regard that as a fruitless expenditure. And someone will have to account for that, especially in light of the recent Supreme Court decision about Mbilo Mbambisa versus the Nelson Mandela Bay municipality, how you treat issues of fruitless expenditure. So you asked whether this is a pattern or what. I wouldn't say that. I wouldn't say it's a pattern, but besides the 2 suspensions, there's a couple of other suspensions that have been instructed to lift. And 2 of them, coincidentally, are also officials at SCM. With all my reservations, because I was investigating these officials, no report was asked for me of my investigations, other than an instruction, to just lift the suspensions.
Which level? Sorry.
The one is the head of procurement, and the other one is also, I think, a senior manager within the same unit. And even when I try to say, based on my investigation reports, there are issues, that have been found. So, for example, one official, I'll issue a final warning letter, and I was told that the other chap who was suspended can just overrule that and change my instruction and all of that. Yes, and without the report
Honorable
being,
Ndlela, please.
engaged accordingly.
It helps with clarity, that's all. Unless if he feels I'm disturbing him, then he must just please say thank you.
So those are some of the issues, Chair, and unfortunately I feel that myself in line, because I've seen emails circulating that I must be suspended because apparently I'm not executing some of these instructions, accordingly. Yes, as I was saying, the charges were not withdrawn, so the matter can still resume and continue. But I can't continue without a resolution of the board, unfortunately. So I'm stuck. The matter is in limbo. I think I've responded to my issues. Thanks.
Thank you.
The legal review of the tender, sorry, that was the last issue. Yes, Member Bolani, in February, I had a meeting with the Western Cape government. And one of the issues that was raised, fortunately my colleague Ian is here, was that, look, we'll go to court. The DG was in that meeting. We'll go to court, we'll oppose SITA and so on. And in my wisdom, I didn't want to fight with the provincial government in the spirit of intergovernmental relations. On the same day, I gave them the Cliff Decker report. That was February. So they've had it. The provincial government has got the report. And in our discussions, the point raised by members was my utmost concern that whatever happens with the tender, the school kids must not suffer. And I even mentioned the example of SASA and Postbank, that we can go to court jointly, get a declarator about the tender, but allow the current service provider, illegal as it is, to continue and SITA be given shorter timeframes to put a new tender in place. For me, that would have been the solution, so that school kids do not suffer, but also we don't continue with an illegal tender. And we had agreed with the Western Cape government. That was in February, and they said they will take the matter to their lawyers, and then there were delays in getting the senior counsel to provide them with an opinion. It only came in September, their letter that they are ready. They have since engaged with senior counsel, and we need to respond, and they have a different perspective on what should happen. So that's where we are in terms of that matter. Thanks. But I can't also proceed with it. If then the report is not accepted, then what's the point of going? We can't pick and choose in the recommendations. So I'm stuck with that as well. That's why I have not as yet responded to the Western Cape government on that matter. Thanks.
Okay, Minister, I did see your hand was up, but maybe before you come in, because this was your session on responses as well, to say that I'm very much aware that now the issue regarding the decisions of the board has been put on the table, right? So I'm aware of that. We had taken a decision in this meeting that we were not having a hearing, but it's only fair that at some point we must give the board an opportunity to state their side. It will not be today. I think the committee has said that we need to go back, reflect. I mean, this was our first engagement with this report. There is also a request that we're sitting with in the committee that we have not yet actioned to yourself, that part of our oversight in December, we would wish to also engage with SITA and go visit SITA. So I think if you would give us an opportunity, Chairperson, I'm saying that knowing that you are present, I'm sorry, Chairperson, knowing that you are present, we do recognize the need for you to be able to speak on these matters, if you will allow us to process it properly. Minister?
Chair, on that note, because I wanted to make an intervention on that note, because there are also some developments that, we're hearing for the first time, which, to hear them here is concerning. And I think that is, why I'd raised this in the beginning. And I think that was what you were trying to avoid. I think the AMD submission now infers that, there is a plan to suspend him. And I think when such things of that magnitude, in the interest of fairness, when they are raised about other people that are in the room, I think then it is unfair to those not to have a chance to deal with it, because it's a very pointed matter that has gone beyond, what you wanted to address. So I think on that note, I think it would be fair, because unfortunately, the openness nature of these meetings is that, because they are broadcast to the world and all of that, what happens in here then stays on people's names and stays on all of us. So as much as I appreciate that you may say that there could be a next opportunity, but I think on this particular one, my strong view is that it's key that, that be clarified. And on the issue of the tender specifically, I think there is a line in terms of the operational nature of things that, it's not for the executive to get into, and would be, and I don't think that's what the committee is encouraging me to do, but I would be very, very hesitant of getting into that. But on this one, because any, inference that there is looming or there's some action about an MD affects the board, and I'm hearing it for the first time in the presence of the board, and I think it's appropriate that it gets dealt in that, so that we live here with a common understanding of, the issues that were then raised here. Thanks, Chair.
Okay. I will give an opportunity to the chairperson of the board to say a word or two, but let's finish the questions. I think the responses that were expected from Cliff Decker.
Thank you, Chair. So the question had been raised about the role and responsibility of the Western Cape and Western Cape Education Department through the procurement process. So with the agency transaction, and I think an honourable member used the word experts. So SITA sits as the expert when it comes to these types of matters. And in approaching the Western Cape, in approaching SITA, the Western Cape would come as a client requiring services in order to procure the services that they require. So what we established through our process is that the Western Cape was in the forefront in terms of the specs, what it required and specifications for the services. So they would then work in tandem with SITA. SITA, however, sits with the responsibility to ensure that the procurement process occurs and it occurs correctly. And then SITA sits with the responsibility to make a recommendation after the procurement process. So what we found was that through the process, and Hilary spoke about the different committees that sat in the different stages, there would be people from the Western Cape sitting in those committees as the client. And sitting there as the client, they would then have the full knowledge of what they required. SITA's responsibility was to ensure that the process ran correctly, the committees were constituted correctly, and then the tasks that each committee had to undertake were then executed correctly. We found that when there were issues of process, procedure, and legality, those were addressed by SITA. So when there were any questions that needed to be dealt with, when there were any legal issues that came up, and I'll give an example of one of the issues which we found not to be an irregularity, which was a question of CIDB and the requirement for a CIDB certificate. In that situation, it was the head of legal at SITA who gave guidance on how to deal with that issue. So whenever legal issues arose through the procurement process, the legal person at SITA would then give the guidance and the necessary advice on that. So SITA's responsibility to the client was to ensure that the process was run correctly. The client's responsibility was to be in the committees, ensure that they participated. They were ultimately the decision maker, but based on the guidance of SITA. When it came to bringing the different aspects of the procurement process together, so we spoke about the different stages, SITA collated that information and went through the process then of evaluating. So the SITA EBAC, the Bid Adjudication Committee, would then sit after all of the processes had been undertaken to then look at the full collation of the results of the committee and then put those forward to the Board Procurement Committee to then consider and then ultimately take that information to the board. It was the board of SITA that then made the recommendation to the Western Cape Education Department. So that's how that relationship worked out. So in us coming to our looking at the responsibility, we looked at that procurement process of client versus the service provider, who was SITA, and ensuring that this procurement process ran correctly and that responsibility rested with SITA, and the ultimate decision to recommend, to make that recommendation to award, was a decision made by SITA. So that's how we separated where the responsibility lay. The next question was in terms of if there was any malice or any malicious intent. So we went through a very rigorous process of looking at any issues of conflict of interest in persons involved in this process. So we looked at officials within SITA. We looked at officials, Western Cape government. We looked at the board of SITA. We looked at a broad spectrum of people, relationships also between the bidders, to see if there was anything suspicious, first of all, or if we could confirm any undue relationships which could have tainted or attacked the integrity of this process. And that's really looking at the issues of corruption, of any issues of fraud. Having gone through that rigorous process, we did not find anything that could amount to any malicious intent or action on all of the parties that we went through the process of looking at. So the maliciousness part or any intention to defraud or any corrupt activities was very rigorously tested, and we did not find any evidence of that. In terms of the irregularities and maladministration, I think what came out here is a process, yes, that was complex, and a process that was tainted with irregularities where it was clear to the persons on some of them, and I'll speak specifically to irregularity 1 and 2, where it was clear that there was a problem with the actions that were taken. So those were actions that were taken. So in the regard of those two, local content and 2 pricing options, there were intentional actions that were taken, and as a result of that, that can fall under maladministration. When it comes to dimension data, again, that irregularity, and when it comes to our issue with the tallying of the votes, those could fall in the realm of negligence, but fall under not having been executed correctly. So that's how we saw the perspective. No malicious intent that we established, but definitely an issue in terms of how the procedures were executed.
Thanks, Chair. A number of questions that were posed to me related to suspensions and the internal disciplinary process that had been undertaken, and I think the acting MD has addressed most of them. Maybe just to underscore, it's only the suspensions that were lifted, and the 2 executives are back at work. And that was at the directive or the instruction, as I understand it from SITA. We were advised, and to the extent that we needed to communicate that to the legal representatives, that's what we did at the instruction of SITA. And secondly, in relation to the disciplinary processes, the internal disciplinary processes haven't been halted, haven't been withdrawn per se. The directive from the chairperson is that the requisite authority be granted to the acting MD or the MD, and that then it will be pursued from that perspective. So that the question about whether or not the executives can be charged again, I think that becomes moot because the charges haven't been withdrawn. I hope I've consolidated all the questions, Chair.
No, guys, please let's not have follow-ups. No. Yes, I am. We're done. Honorable Shongwe. Yes, Honorable Shongwe.
Kancane bayavela che. Kancane nje bayavela. Sanibonani bakithi. Minister Nyabingelela through you chair. No, just a quick one, Chair. Ngicela nje ukuthi sicelele i-SITA to provide us with all their disciplinary actions on this issue. And then at the same time, I wanted to ask how much did it cost the entity as well? Can they provide that to us, please? Kodwa bona ngiyabonga Minister, cha nibhizi siyabonga ne-Western Cape, cha nibhizi. Nibhizi
Honorable Bodlani.
Siyabonga.
Chairperson, I really don't want to take us backwards. And this is for me to put it on the agenda so that the colleagues in the portfolio committee know what my intention is. Chairperson, I think there is deep-rooted corruption at SITA. There is deep-rooted maladministration. There's delinquency. And I would love, whether as myself, as a member of the portfolio committee, or as a collective, as a portfolio committee, that we institute an inquiry into SITA. Because what we are hearing here could really be the tip of the iceberg. I'm sorry, but as Honorable Acting MD was speaking, I had chills down my spine, and a part of me felt like I'm fearing for his life. Because if you are going to be a hindrance to people who think they can loot the state, then you're a moving target. And unless we nab and put an end to this, we are not going to succeed. And hence the question that kept coming from the members to say, is this an isolated incident? And sitting here, we are focusing on just the one tender. But I really have a sense that it is deeper. So I don't know, on your advice, whether do we do it as a collective, or do I then write to you myself to say, how do we institute a commission inquiry into SITA? Because at the end of the day, if we are going to be spending 5 million on something that is not even your core function, disciplinary processes, then we are losing the battle. I'll take guidance from you, Chair.
Thank you, Honorable Bodlani. Honorable Bodlani, maybe to respond and say, please may I plead with the committee that we conclude this meeting. I think there's a number of issues that have come up here, and please, Chairperson, I'm coming to you. There's a number of issues that have come up from this meeting that the Minister would probably want to reflect on. Similarly, the issues that the Portfolio Committee would want to reflect on. And like the issue that you are raising, Honorable Bodlani, I suspect that it may be part of the discussion of the committee as to how we take this matter forward. Chairperson, Madam Musidi.
Thank you, Chair, and thank you to all the members of this committee. And thank you for the opportunity. I really appreciate. I suppose we were not supposed to be saying anything, which was odd to me, because to be called the whole board to come and say nothing, I think we could have stayed back and saved the millions that we're all worried about. But just on a lighter note. So I think the first point, Chair, because I want to come back to responding to the MD so that the members don't think that we are rogue and we don't care. We care deeply. We might miss the point and punish the wrong people. So I just want to create that clarity quickly. It won't take 5 minutes. Before we were unlawfully dismissed, we were already starting to investigate this particular tender. And as we were about to start, Minister Gungubele withdrew it. It's just a fact. I'm not being defensive. I like what they have presented as CDH. It gives us a basis. But before we were dismissed, we were given an instruction to do it, and we were starting, and we had to stop. So could we have ended up with something different? I don't know. But we were going to do it. So it's not because of us that it stopped or anything. And the second thing, Chair, is that it's a very complex thing that happened here. So we get reinstated. With a Part A, we still have to do Part B. You find a CDH report. You try to look at where it is. The CDH report is written draft. So you say, okay, that's okay. So it means the work in progress, and we will continue with the other former board members who were there so that we make it a final report. This is our simple understanding because it's written draft. And we have a discussion with CDH. And they also say, look, quite frankly, we've never presented this report to the board. So to us, it's still a draft. So we don't have a record to say this is a final report. And of course, as a board, to be responsible, we then decided, look, let's get a legal expert to help us to bring everything together. And that is not to say there's nothing to answer to. The corruption is inside and outside SITA. And I think most of the institutions that we work with, we know that. So we actually got a legal company that started the work immediately, because I realized as well that I want to know what actually happened if there is such a big issue that is actually a storm. So we instituted that to be able to complete the CDH report so that we then start instituting the right disciplinary processes to people who must be disciplined according to the, but it had to be complete. And just 2 examples, there were some board resolutions which said people must be given the right of response, which they didn't. And I thought, it will be unfair. Can you imagine if you get interviewed and you see a report somewhere and there's a mistake and you are not given an opportunity to actually correct? So that's why we did that. But there are a lot of things and I won't go into them. So, Minister, where we are now in terms of the people who were suspended, we are given 7 days. I get a request on the 5th day to say, do you charge or do you dismiss? I don't have information. CDH is a draft report. I'm still looking where are the issues. The best thing for me to do was to actually institute and make sure that the charged employee must come back and do the work because we're paying him anyway. But that doesn't drop the charges. It says that he comes and we will do it fairly and equitably. And that's what happened. So it's not like it was lifted. It's not like it was, we had no other way. Either you do it, you are left with 2 days, or you actually bring the individual back. So I think the second part, they actually won at the CCMA. It was not a lifting of a suspension. I think it's not the right way to put it. It's not correct. They went, I don't know, they went to many CCMA cases and whatever, but they actually won each and every case of theirs. So based on this report. And the suspension took more than, the policy of SITA says that when you are suspended, it must be concluded in 3 months. It was over a year or 9 months or whatever, and they're still sitting there, they don't have charges. Chairperson, I'll never be unfair to anyone. I've been subject to it, and I will never back down to see anyone punished unfairly. So the idea is not to cancel this tender. The idea is not to cancel this investigation. The idea is to make it complete and to make it fair. And when we move, we don't leave those who are corrupt walking the streets and those who are innocent actually being punished. And this is where we were. The last one on the rumor of the AMD. When I started, I had a meeting with him. I'm very open with anyone. I said, look, I do not know what it means because you were appointed by a board which is said to be unlawful. So we have to find a way of ratifying. He's here. I said, we have to find a way of ratifying this appointment. As I was doing that, I received a letter from the public protector. The letter was to Quorum Pillay, and the letter said, we have a whistleblower saying you appointed an AMD wrongly, unlawfully, the CPO unlawfully, and other things. And Chair, quite frankly, I was weary. I've just come back from a court for 14 months. I was tired. And I just said, look, Mr. Dave Boucher, can you just respond and tell the public protector how you have done this? Guess what? The appointment was unlawful. So from the SITA itself, his appointment, the report says so. So I sit there, go like, okay, do I just send the public protector a report? Yes, I would send it. And I notified the department to say, I have responded this way because it's likely to have been unlawful. Now, whether the rumors come from there or not, I don't know, Chair, but I wasn't aware of the suspension. How do you suspend an acting MD whose contract is ending in January? It would be silly. But I've been very open with him to say, let's look at this and see how your appointment can be legal or not. But now, there's always rumors, and surely we shouldn't maybe chase rumors because they might actually dilute the truth that we're trying to chase. And so, Chair, I think just in conclusion, I didn't know, yes, we were not going to go into the presentations that we presented, but when we were reviewing the CDH report, like I said, it was not to cancel it, it was to make it complete. To go back down and say, but where did this tender start? Can those people, because as a board, you just check, is there an internal audit report, is there a legal report? And that's why you see it. Because I don't adjudicate. I do not check local content. But when you start saying you have to be held accountable, I ticked all the boxes and we've shown that we've done due diligence. Our due care as a board was done. And that's where the discussion is. Let's just understand where is Cliff Decker coming from. After that, we were going to bring it back to the department to say this is where we are in terms of the investigation of this report. So, Chair, I hope I've addressed, and I was starting to feel like we are branded as rogue. We are not. And that's all I can say. But let the processes be open and fair to everyone to be able to present their case. This tender, for example, is so big. It started in 2022. It was started by Levoyo. He was there. He's now on this other side. Now somebody can say, is that not conflict? You know, you start looking at those things. Where do you raise those things? But of course we trust, and we trust that he's working diligently as a board member. But thank you, Chair.
Thank you very much, Madam Chair. Minister, honorable members, I want to close this matter on this note. Minister, you have been here throughout the presentations. I think you've heard the issues that have been raised by Cliff Decker, by the CEO, the MD, and also members. And I'm sure you would have picked up for yourself issues that are of great concern. And I do want to make the point, Minister, that the committee is not insensitive to the fact that you are also a new minister in the portfolio. I think we appreciate that. However, this is one of the issues that we are hoping will require your urgent attention. It's not the first time SITA is coming up, I think, in such a manner in this committee. And with saying that, I'm requesting that, Minister, perhaps you go off and reflect on the actions that you are going to take. We're going to do the same as the Portfolio Committee to write to you in terms of what would have been the outcomes of our deliberations. And once we have confirmed the date for our oversight visit that we are requesting that you take us to SITA 2, then that will also be communicated to you. Thank you very much for the presentation. I am also losing members. Honorable Subrathi had to go off to prayers. Honorable Bodlani is also leaving because she has to catch a flight. So let me thank you for your time. Thank Cliff Decker-Hofmeyer for having availed yourself for this presentation. I like the in your terms of reference, you say, be present to present whenever required, with no limitation. So I underlined that when I was reading your report. So thank you very much. I think we may release you. Thank you to the board. The fact that you did not engage as fully as you could have, it's not because we undermine your capacity to respond to the issues that were raised against you. But as we indicated, this was our first foray into this issue, just to get our minds and understand how we would process it further, given the fact that it would have emanated from the committee. So thank you very much. Maybe let me release those who would wish to leave. The minutes, I'm going to request members that we defer the minutes again to our next meeting, because I do want us to consider minutes, and just ask Mr. Ngoma in 2 minutes to give us an update on the ICASA council process, and to indicate, Member Botlani, the oversight plan. We will also present it at the next meeting, because that's not yet finalized, for the December one. We're proposing Gauteng instead of KZN. Let's look at that as part of that. Thank you very much. Ndlela, we asked Honorable Ndlela, now you're going to get me into trouble.
Honorable members, especially of the, honorable members, this is just a short brief on the process on ICASA Council. Can all those that are leaving do so quietly? This is just a quick update, members. I'm not really going to take you back, but just to sum up, members will be aware that this matter was referred to the committee on the 7th of August. She's going to the committee next door. Honorable members, as I was indicating, that this matter was referred to the committee on the 7th of August, and the committee had already taken a decision to advertise and call for public hearings. My apologies, for public submissions. We had a total of 270 nominations. The subcommittee deliberated and proposed 17 names to the committee. However, the committee increased the number to 20 with the inclusion of 3 female candidates, Ms. Jagans, Ms. Janchizwakala, and Ms. Tsebe. As such, the committee had 20 shortlisted candidates. Dr. Charles Alistair Lewis, Advocate Lutando Simpwe Mkumatela, Dr. Mandisa Nompumalelo Kumalo, Dr. Chifua Joshua Maumela, Mr. Dick Enrisono, Ms. Cassandra Gabriel, Mr. Demetrios Martinez, Mr. Andrew Matseke, Mr. Matibela Silepe, Dr. Neil Croft, Mr. Jean-Pierre Klein, Prof. Ndiboniswani Chizumba, Mr. Madoda Mkakwe, Mr. Tabiso Tukani, Prof. Mpo Primus, Ms. Karabo Muhale, Mr. Melusi Mtetwa, Ms. Marisa Jagans, Ms. Zintle Janchizwakala, and Ms. Dichecho Lydia Tsebe. The names of the candidates members were published, and we had given a period of 2 weeks for members of the public to comment on the names. Safe to say, Chairperson, that we've had a number of comments, but it's all just messages of support. There's nothing that has that's negative that has come against any of the remaining candidates on the list. Honorable members, I said remaining candidates because since we have shortlisted, we had 2 withdrawals. One was from Professor Chizumba, indicating that he was recently promoted in his employ, and the other one was from Mr. Mzwamadoda Mkakwe, who also indicated that there was a promotion which could lead to a possible conflict of interest if he continues with the application. So that leaves the committee with 16 candidates. I have then, honorable members, 18 candidates, yes, Chair. I have done the process. The processes are running, which relate to the qualification verification of candidates, as well as the personnel suitability checks with the State Security Agency. But we will be moving with the interviews. We'll be going ahead with the interviews next week, as that process is also running. But we always aim to have that process completed, the one of verification, before we actually get to the last meeting where the committee makes the subcommittee makes the recommendations to the committee. Honorable members, the interviews will be held next week, 21 and 22 November, physically at ICASA headquarters in Centurion. And one of the reasons why this decision was taken was because out of the 20 shortlisted candidates, 17 were coming from Gauteng. And Parliament has a responsibility to bring all the candidates to Cape Town. So we would have incurred a lot of cost if we had held the interviews here in Cape Town. I can safely say, Chairperson, that based from the calculation that I've done, we've actually saved Parliament quite a lot of money. It could even be over 100,000 rand for 100,000 for holding these interviews in Gauteng. Chairperson, the latest update was that the interviews will be broadcast on Parliament TV. So we have our IT services team that is liaising with the ICASA audiovisual services team in order to set that up. And the candidates have been informed of the interview dates. Yes, and the political application for the committee to hold those interviews in Gauteng had been approved. Just another issue, Chairperson, relating to one candidate, Prof. Mpo Primus. She's indicated that she'll be out of the country. She's leaving on the 19th and therefore would not be able to do the interview physically. We looked at all the possibilities, and I have identified that if after the last meeting, the last interview, Chairperson, which is scheduled to finish around 6 o'clock on Thursday, then members can have 2-hour break to travel between ICASA head office and the hotel, and then at 8 o'clock we can set up a virtual meeting just to accommodate that one candidate, because she's only back in the country on the 9th of December. So that is the proposal, Chair, that I'm putting here, that perhaps she can be interviewed in the evening, but it will be the decision of the committee on how it deals with that matter. The Secretariat team is also working on themes. We normally produce themes for the interviews, which once the document has been prepared will be run through the office and then shared through the Chairperson, and then will be shared with the members. We're looking at latest Monday, honorable members, for you to have that document. And the plan, Chairperson, is to also, as we'll be holding these interviews on Thursday and Friday, we're planning that at least by Wednesday, the 27th November, the subcommittee should deliberate on the outcome of the interviews and make a recommendation to the committee, and on that same day, if the committee can then adopt a report. The reason why we've set up the date of the 27th is because we'd like to have, there was on the letter that I presented to the committee from the Speaker, we are requested to expedite the appointments, but that doesn't mean that we should not be doing thorough work. So, honorable members, I'm hoping that by the 27th will be done so that this matter can go before the House, before it rises on the 3rd of December. Chairperson, there's ongoing discussions between my office and members to finalize travel logistics. I can safely say 90% of the members, I have had a discussion with them, and will then, yes, I think that will be my update for now, Chair. Thank you so much.
Clarities. Thank you, Mr. Ngoma.
Thank you, Chair. Just a quick one. Chair, in similar interviews, there is normally an apprehension by members of the panel that if it's live and other candidates have access to that feed, the last one normally performs better than all of them. I'm not sure how you're going to deal with that. I've been in few panels as well, and that is what we noted. Even though some of them would have been closed sessions, but the one who comes late for the benefit of being fed by those that came before them normally outperforms the rest. How are you dealing with that? Thank you, Chair.
Okay, Mr. Ngoma?
Thank you, Chair. Chairperson, thank you, Mr. Matafa, for that question. Chair, we've always held the interviews in public. We appoint 3 boards, the SABC, the MDDA, as well as the ICASA. And all the interviews, we've always held them in public as part, as it is also clearly stated in the Act that the process must be open and transparent, and we must show adequate public participation process. Yes, and Chair, that issue was once raised, but it was not seen as something that could eliminate the public. Thank you, Chair.
Let me help you. I think the issue of the open process is what we are underscoring. I did raise this matter, I think, once in the subcommittee where Honorable Bodlani responded to me, and you can assist also, Comrade Mataf, Honorable Mataf. I was under the impression that in Parliament, it's like in the public service, that we have set questions we ask, so by the time people come, they know the answer. And the response I had got was that we rather have themes, where members will then raise their questions within the theme, so it is not that our questions will always be the same to each candidate. That is what I was informed. Hence, then that issue is dealt with in that manner. Honorable Ndlela?
Honorable Matafa is raising. Should we then perhaps, and take into consideration what you highlight as a slight challenge, having to leave the head office and then go to the hotel to do that interview? Why don't we start? And firstly, are there no facilities at the head office to accommodate an interview online? That's the first one. Because if that's the case, then we just start with the person that we're going to end with, and so therefore they don't have an advantage over the others on the questions. That's a proposal.
Honorable Ndlela, I suspect the issue of this individual is the diary of the person. I don't know it. I'm so sorry, I forgot the name. They are traveling out of the country on the 20th and 21st, and my suspicion that the proposed time of 8 o'clock is the time that the candidate is available. But perhaps let's go re-look at it, because I know that they had initially asked for an interview before the interview started, I think a day or so. So if you allow maybe the Secretariat, let's just look at when she's available and when we're able to fit them in. Honorable members, if there's no other issues, so we're deferring the minutes, and that was the last item of the agenda. So I declare the meeting closed, and we will meet virtually on Tuesday to consider a number of issues around the SABC, and maybe while members are here to take the committee into confidence on the issue of SABC. On Tuesday, we were supposed to consider the report around issues of analog switch off, which the committee had raised quite strong views about. We're supposed to consider the issue around the department's responses to the SABC bill. As things stand now, we have no correspondence indicating the withdrawal of that bill from the Office of the Speaker. As chairperson, a letter was directed to me to notify me that the minister had written to the Speaker indicating that he was withdrawing the bill. And I think members would know that we would then expect that the matter is referred to us or we are notified. So we have not received any such correspondence from the Speaker. So we have kept that matter on the agenda for Tuesday. So we'll be expecting a response from the department in relation to the SABC bill public participation process. Then there was a third thing, the DTT, DTH, which Honorable Botlani had asked that we must raise with the department. So it's analog switch off, SABC bill and DTH are the agenda items with the SABC on Tuesday, and I think it's a full day. Sorry, Honorable Villegas, you look very, very confused. Are you just walking in? We had closed the meeting. So I was saying to members that on Tuesday, we'll be having a virtual meeting, and on the program, it was focused on issues around the SABC, which was the analog switch off. You remember the discussions that we were having with them. There was the matter of the SABC bill, because that was the date that the department was meant to have come back with the responses to the public participation process. I then informed the members that while I had, and yeah, I don't like speaking as an individual, but while the minister had written to me to inform me that he had written to the speaker about the withdrawal of the bill, we have had no further communication or referral from the speaker indicating the withdrawal or otherwise. So we had kept the issue of the department's responses to the public participation process on the agenda for Tuesday. And then the last issue was around the DTH with SABC moving from DTT to DTH, which we had requested that they come report on. So that was the last issue. Honorable Vilakazi?
Thank you, Chair. Just on that matter of the DTH, I noted and I kept meaning to ask that it's the department giving us the update on that. Should it not be the SABC itself doing the same? Also, when we had the meeting with the SABC where this came up, it was the SABC CEO who requested the opportunity with the portfolio committee to come and explain further. So I don't know whether it'll do them justice to have the department speak on their behalf, or in fact, I think it might benefit the board, the committee better to ask the questions directly to the people responsible.
Well noted. We'll look into that in terms of how we would have also communicated to them, Honorable Villegas. I suspect that it is one of those speaking to the SABC through the department, but you're quite correct. It should be the SABC who presents it. I'll make sure that is done. Okay, Madam Zaytun, you've noted that issue. Thank you very much, colleagues. I'm not sure how we're going to schedule this issue of a follow-up on this discussion, but there's quite a bit of problems in the SITA. I share Member Botlani's view that, I had chills when they were speaking as well. So on Wednesday, the Secretariat is proposing Wednesday. Can we come back? On Wednesday, we're supposed to have a joint committee with Science and Innovation, looking at the satellite for communication strategy that has been developed, I understand, by the National Space Agency, CENTEC, with perhaps involvement from the Department of Defense. We're just struggling with that meeting at this point in time because we had agreed on virtual meetings as a subcommittee for next week. Now, Science and Innovation seems to prefer a physical meeting, and we are still having ongoing discussions with them whether do we then defer it to a later date, or we can persuade them to allow that meeting to be virtual, because I suspect at this point it's really just a briefing session, just to know what they're happening. We will communicate with honorable members then in that regard. We'll hope to see you again, Honorable Blosser.
I'm here, Chair. I'm here now.
Thank you, honorable members. The meeting is adjourned.
Long live the Chair.